David Proctor, he's in the witness box.
Thank you. Mr Proctor, do you promise to tell the truth to the court?
I do, Your Honour.
Thank you.
Mr Proctor, can you restate your full name for the record?
Yes, my full name is David Proctor.
And what's your current occupation?
Retired.
And how long have you been retired?
Just over 12 months.
Okay, so sometime in 2021.
Yeah, I finished with the Northern Territory Police on, I think it was the 2nd or 3rd of September 2021.
When you retired in September 2021, how long had you been a police officer?
It's a strange thing that you remember the exact details, but 34 years and 7 months.
And all of that in the Northern Territory?
All of that in the Northern Territory.
I won't ask Your Honour, so I won't ask you to take Your Honour through a year-by-year history of your time with the Northern Territory Police Force, but can I ask you to explain what your substantive position was when you retired?
Yeah, my substantive position when I retired was at the rank of commander, and the area I looked after had a few changes given some youth justice stuff that Your Honour might be aware of, but I think it was the Territory Operational Support Command. So the areas that I had responsibility for were youth justice, prosecutions, and territory communications, and the school-based policing areas.
And during your very lengthy career, you served in all urban areas in
I'd served in, so Darwin, Tennant Creek, Alice Springs and Katherine.
And you also served remotely from time to time?
I served at Harts Range, I think in 99. My first remote station was Harts Range, then I moved to Tennant Creek, then I went to be the officer in charge of Kalkaringi, then into Katherine as a detective, then to Darwin as a sergeant, then to Borroloola as a substantive sergeant. Sorry, this will go on for a while, but I'll try and keep it. Then to Alice Springs as a detective sergeant, then to Darwin as the Senior Sergeant Major Crime on promotion. And from there, I think I stayed in Darwin for a while as a superintendent, and then promotion to commander in Katherine as Commander Northern Command.
So you became a commissioned officer in 2000, I think, is that right?
Yeah. No, the superintendent, I think it was 2004 or 5 as a commissioned officer was superintendent.
And in the 15 or so years since, you were assistant commissioner. You held every assistant commissioner role in the Northern Territory Police Force, is that correct?
Yeah, I relieved in every assistant commissioner position.
You've also got significant investigative experience, is that right?
Yeah, as I say, a detective, senior constable in Katherine, detective sergeant in Alice Springs, and whilst here relieved for extended periods as the senior sergeant, and then was promoted to the senior sergeant of the newly formed Major Crime Unit.
Can I just pause you there? At that time, the Major Crime Unit, the portfolio of the Major Crime Unit covered everything: sexual offences, homicides.
Yeah, so there were two streams at that time. There was two senior sergeants. Mr Pollock had been promoted to senior sergeant in an area that they called the Special Operations Section, which was mainly focused around organised crime. And I had the Major Crime portfolio, which was sex crimes, fraud, computer crime and general crime.
And I take it from your last answer that you've worked with and around Mr Scott Pollock you did work around each other for many years.
Yeah, we were detective sergeants in Alice Springs together, and then obviously in Darwin. And
your level of respect for him as an investigator?
Very high, obviously. He's a very good investigator.
Now, in addition to your, I suppose, investigative experience in crime, have you ever investigated any coronial matters?
Yeah, certainly. I suppose at a lower level, as a senior constable in Katherine, you would, not that I'm trying to diminish them, but you would certainly attend, obviously, non-suspicious deaths or homicides. I suppose relevant to this portfolio, I have investigated deaths in care at correctional facilities. And while I was the commander of Katherine, at the time Deputy Commissioner Mains appointed me as the officer in charge of the death in custody of Joshua Walsh. That matter related to initially an abduction at gunpoint of Mr Walsh's girlfriend from the women's shelter in Darwin, which I guess resulted in him being located at a unit in Ludmilla where the TRG had deployed and put in a cordon and containment, and he suicided by shotgun while he was in the premises. And I was appointed by Mr Mains to do the investigation into that on behalf of, at that time, the coroner, Mr Kavanagh.
In 2020, you were the incident controller for the COVID-19 pandemic, is that right?
Yes, that's correct.
And it's at that point in your career that you were contacted and brought into the fold, as it were, to be involved in this investigation.
Yes, however, prior to that, I had been acting as an Assistant Commissioner Crime for 10 days while Mr Antisich was covering for, I think it was either Mr Murphy or Mr Smallpage. And during that time I had, I was involved in the discussions around the selection of Mr Alpert.
Yes.
And then my only other involvement prior to coming on board in relation to the Coronial matter was, obviously I was the commander in charge of prosecutions when the initial brief was put to Mr Bryson.
Did you have any involvement in the development of that brief?
No, the only involvement I had was a phone call from Mr Bryson where he expressed his concerns in relation to information that was required from the DPP, and I provided some advice to both him and Mr Dole as to how they could go about either resolving that issue.
And I'm right, aren't I, that the concern was that it appeared that oral advice had been given from the DPP recommending a charge of murder, but there was some concern that that advice should be put in writing, at least in the form of an email.
Yeah, so normally when the charge of murder is laid, approval from the DPP is required. And Mr Bryson, on getting the brief, indicated that that wasn't there. And so I think an email or similar was requested, however wasn't provided. My advice to Mr Dole, who said he had been in the meeting when that approval was given, was that if that was the case, he could possibly sign the indictment as a deponent, and we went from there. The reason for that being, if the DPP had not provided the advice, obviously they would progress the file the next morning in court anyway, and so yeah, that was pretty much my advice.
I want to ask you about, obviously when you became involved in the Coronial investigation, some progress had been made investigating, is that correct?
Yeah, so I came in, I can't remember the exact date now, but I think it was roughly 8 months after the incident occurred, so it would have been around June, July possibly. Sorry, I can't recall the exact date. And at that point, pretty much, I suppose from my perspective, in terms of physical investigation, pretty much most of that had been undertaken by Mr Pollock and his team.
I don't use the word pejoratively, but you inherited some draft reports that were also being developed for the purpose of the coroner.
Yeah, so how those draft reports or information, or however it will be described, came about was, I suppose at the point that I took over, there was a request from both Mr Antisich and the coroner to have some form of report in place. Certainly from Mr Antisich's point of view, he wanted a final report by, I think it was November, which I thought at the time was a little bit ambitious, but so between Mr Pollock and myself, obviously Mr Pollock had been in charge of the investigation for some 12 months and had quite a large amount of information that he had already reviewed, and so my thoughts were that he would start preparing a draft report or provide information to enable a final report to be prepared. Initially in our conversations, and my view was always that it would be perhaps a co-signed report. Obviously that didn't come to fruition because Mr Pollock took leave without pay pending retirement prior to the report being finalised.
I just want to ask you a couple of questions about the report. You've referred to it as a final report. What do you see the role of a coronial investigation report like this being?
I think that is my final report for the time that I was the coronial investigator. I think within the report you'll see there are areas that we were not able to, I suppose, for want of a better term, resolve or conclude. And I think in my report I advised that there are certain elements that would either be further advanced or the issues resolved or made more clear either through the coronial inquest or at the trial.
So in a sense, the function of the report is to draw together the material that had been gathered and then identify issues without necessarily resolving all of the issues.
Yeah, look, from my perspective, the way I wrote the report was to examine all the information. We'd been given some clear directions from the Deputy Coroner, or the Coroner via the Deputy Coroner, on what issues they wished to have explored. It was to go through those. For me, it was very much looking at the systems, what systems had been in place, what systems had failed, if possible, why had they failed. And then in the report, I obviously make considerations. They're not recommendations. In my view, it's Her Honour's job to make recommendations. But they were more considerations for the coroner, but also a copy of that document is provided to the police. And I was aware that we also had an organisational response committee to address some of those issues and for their information as well.
Now, I think you identified one of the reasons that the issues necessarily remained unresolved, and that's just because the criminal trial and coronial process hadn't taken place. Is another reason that there were good reasons not to get in touch with certain witnesses while the criminal process was being undertaken?
I think for the issues in my report, it was more that those witnesses were subject to being witnesses at the trial. And I had some discussions with the Deputy Coroner around that as to whether or not we should progress, even just try to get statements or interviews purely on those issues. In my mind, I didn't think we should have, and he agreed with that we didn't want to step over the mark of, at that point, we were very close to being, well, in our minds, trial was going to commence quite quickly. So we didn't want to be seen to be interfering with witnesses. I believe prior to my arrival there had been some issues raised around members being required or being interviewed or spoken to on multiple occasions. And I think Mr. Antisich had been approached by the association in relation to that and the welfare of members. So I don't believe that, I think there'd been some agreement or direction that unless it was absolutely essential, further statements would not be obtained from those people.
Now, you ultimately signed the report.
Yes.
And so you adopted the report. It was your report.
Absolutely.
Even though Mr. Pollock had written some part of it, you took responsibility for it and owned the report, is that
yes.
right? But it remains the case that there are parts of this report that you did not draft yourself, is that correct?
No, that's correct, and I think I make that quite clear in the report, that an issue is identified, and some of those issues were identified in the information provided by Mr. Pollock, and that they are still live issues, or at the time they were still live issues, and that they, again, may be resolved either through evidence adduced at the trial or in the coronial, or from further investigation.
Do you have a copy of the report in front of you?
I didn't bring one with me, but there might be one. No, I don't.
If not, we can provide you with one. Alternatively, it's document 1.1 on the brief. 1.1A. 142, please.
Thank you.
You can see a heading on that page 142, investigative bias expert witness.
Yes.
Is this one of the unresolved issues that you were talking about?
Yes, and look, I have read the report prior to appearing today, and I would submit that most of the areas that sit in that investigative bias component are the issues that we were unable to resolve.
Okay. And so you weren't purporting to conclude that there was investigative bias, you were just saying being unable to contact these witnesses because the criminal trial is ongoing and the coronial process hasn't commenced, this is an unresolved issue that is worthy of further consideration.
Yeah, I think I try to make it, I think, in my mind quite clear where I say that these concerns are in the report by Mr. Pollock. and that they all raise concerns of potential investigative bias. And then I clearly state the summary and rationale for these concerns are detailed in the following paragraphs, which are taken directly from the draft report
Of Mr. Pollock.
of Mr. Pollock.
So,
And then, so I set those out, I believe. And I apologise that it is fairly lengthy, but I think at the very bottom, if I go through this.
now, can I take you to one
Yep.
specific part of this, which is or are pages 146 and 147 of the report,
Yep.
where there's some discussion of Detective Senior Sergeant Barham's expert evidence.
Yes.
Now, I take it that you've been following these proceedings, the Coronial proceedings.
Being the good retired person I am, I haven't been sitting in front of the screen every day and watching it like a soap opera. But yes, you're obviously interested in whether your name comes up and what it might be. It's come up a few times. Yeah, look, I have, and obviously in preparation I have read some of the transcripts of evidence and heard some of the footage that has been, some of the evidence that has been given on video as well.
Now, an opinion is provided, I take it by Mr. Pollock, but you would identified it as an issue in your final report about potential confirmation bias on the part of Sergeant Barham. You agree?
Yes.
Now, that opinion is based on some assumptions of fact. Would you agree?
Yes.
For example, it appears to be based on an assumption that Sergeant Barham attended a select committee meeting with family members in Yuendamu.
Yes, I think that's the assumption of facts that were available to the investigative team at the time. I just want to clarify that it was at the time, yes.
I'm not in any way being critical. Yeah. I suppose what I'm coming to is Senior Sergeant Barham has been asked about these passages and has given evidence that he did not actually attend that meeting and instead conducted, in effect, a view of the crime scene in Yuendamu. Now, he has also clarified that in his view, at no time was he a part of the investigative team, and has given evidence that far from being rushed, he only provided his first statement in March of 2020. Having followed some of the evidence and in light of those facts, to your mind, is the potential issue resolved?
I think it goes to the comment I make on the bottom of the report on page 148, where I say further inquiries or evidence may determine if the evidence is opinion-based, is evidence or opinion-based. I guess on that evidence, the evidence is that the information we initially had has changed, and that I think it's hard for me to say 12 months after the event and not being involved in it whether bias wasn't or wasn't present, but I think it's fair to say, in my mind, it was the potential of bias. Obviously, Mr. Pollock had a more firm view, but on the evidence I've heard in relation to, and that you've just provided, if it's not the case that he wasn't part of a delegation and that he didn't go to those meetings, then obviously the information we were provided has now been seen to be incorrect.
And although you couldn't exclude the possibility of confirmation bias in any case, you wouldn't be of the opinion that there was confirmation bias in this case?
Not on the more recent evidence provided, no.
The second topic I wanted to ask you about concerned the new general order, crime, homicide and serious investigation. It's a draft general order. Have you been provided with a copy of that?
Yes, I have.
I just wanted to ask you one question about this document, and you can find the relevant passage on page 37. Before I ask you to read that, can I just ask you this? Would you agree that in cases of deaths in custody, the actual and perceived independence of the coroner from the police force is important?
I would submit it's absolutely paramount.
I suppose my question for you is this: in an ordinary coronial inquest, it's quite normal for the coronial investigator to send the final report up the chain to the assistant commissioner before it is then sent on to the coroner. Would you agree that in cases of deaths in custody, it might be more appropriate that the coronial investigator send it simultaneously up the chain of command and to the coroner?
So my custom and practice in this matter and also in the Walsh matter, which I would class as fairly sensitive matters for the police force, where I would, in this particular matter and also in Walsh, I provided my final report to the coroner's office and sought permission to then provide it to the Northern Territory Police.
And am I right in thinking that the reason you do that is that in that way there can be no suggestion that senior management within the police force is leaning on a coronial investigator not to criticise the police, for example?
Absolutely.
Yeah, those are my questions.
Yes, Ms Moreau.
Thank you, Your Honour. Mr Proctor, my name is Paula Moreau and I appear for the Brown family of Kumanjayi Walker.
Yes.
If you can keep your report there, because there may be some details that I'd like to take you through. The first area is the issue of Mr Roth's arrest, which you deal with at page 82 of your report.
You'll have to excuse me, I didn't quite realise how long it was when I wrote it, so I apologise.
Well, it was riveting reading, if I can say that.
I tend not to agree after I had to read it again in the last few days, but thank you very much.
Have you got that passage?
I'm nearly there.
Page 82.
Yep, hang on. 83. Oh. There must be a quick way of doing this, but I might not know. Bear with me, I apologise.
Make your computer.
Okay. Oh, yes.
Now, you address a concern that had been raised and then investigated about whether or not Mr Rolfe's movement to Darwin was done for a proper purpose, correct?
Yes.
Can I assume from what you've discussed in your report that you did not investigate any concern about favouritism in relation to the timing of and the position taken by police on the telephone bail application heard by Judge Birch?
No.
Now, I haven't seen a statement from Detective Senior Sergeant Newell, who actually made that application. Do you know whether there was any investigation as to any written material being emailed to Judge Birch for the purposes of that that bail application?
No, I don't. As I say, we didn't necessarily look at that.
Okay. To your knowledge, is there data held by Northern Territory Police that could be accessed by a team such as yours, which could tell us whether applications for bail for murder have in other cases been made over the telephone?
Look, you would probably... I don't think there's data. You may have to go and look at the actual prosecution briefs, because obviously it would have... it might be in the IGES system because obviously that's made to a judge. Yes. And the judge, my normal understanding is that then they update at some point later, those details are then placed into IGES. So it could possibly be from IGES. But then as to what the contents and information is provided to the judge at the time, I don't know if that would necessarily appear in there.
Certainly. So there might be some statistical information, but not any real substantive information in relation to...
You could possibly get that out of the IGES system through Attorney General's Department.
Do you know yourself whether applications by phone for murder in particular are common or even ever done, other than in this case?
Well, applications for... because of the... look, you have to bear with me because I haven't looked at the Bail Act for at least 18 months.
It's certainly permissible under the Bail Act.
Yeah, and it is, but
it's a regular
in most
occurrence.
cases where you're charging with those offences, even if bail is refused, a bail application is made in accordance with the Bail Act. So I would submit yes, in most cases, bail applications are made.
I see. But you certainly don't have any direct knowledge about murder charges in particular in that
No, I
sense.
can't recall in my experience where police bail has been granted to someone that I personally have been involved in the charge of murder.
And in a similar, given your extensive experience, is it at least your experience that applications, when they're made by telephone, are made by members of the arresting team versus, for instance, the watch house sergeant?
Yes, and I think that at times is because, although they are the investigating team, they also have probably a broader understanding of the elements required to address the elements in the bail application, whether it's for or against the person getting bail, whereas the custody sergeant really is in the watch house dealing with every person in custody. Even an initial brief for charges as serious as this has some complexities to it, and even the bail applications for these matters would sometimes be complex. So I think that's probably one of the rationales for it.
Do you understand that both at different times might make those applications? That is, either the watch house sergeant or
Potentially, yes.
Now, did you, as part of your investigation, ascertain whether Mr. Rolfe spent any time in a cell in the watch house before he was granted bail?
No, I have to be honest and say from what's in the report and from my recollection, I don't think we looked that closely at those particular matters.
Thank you. The second topic is the issue of dragging, which is one of some importance to my clients. You deal with it at pages 92 to
Yes.
94 of your report. While you're turning that up, I might ask you, because I expect you'll know, as you've noted in your report, it was a requirement under the custody and transport instruction that alternatives to dragging by limbs be utilised, correct?
Yes.
And that, of course, was a change in policy that was taken initially from the Royal Commission into Aboriginal deaths in custody and
Yes.
then informed by subsequent coronial decisions, correct?
Yes, that's correct.
Now, ordinarily one might think that resuscitation efforts would occur in situ in a situation where someone has sustained a firearm injury, correct?
Yes.
Now, of course, in finding in your report that this was a regretful component of the factual matrix, you considered it somewhat unavoidable, at least in your report, which I'd suggest accepted the officer's fears of reprisal in the location at face value, correct?
Yes.
Now, accepting that may be the case for a moment, did you consider that there were other alternatives that could have made this a much more humane event? For example, using the 4 or 5 officers who were present to carry him without dragging him to a vehicle?
I accept that could be a possibility, but I think based on, as I say here, my view that it was regretful because of the fears of reprisal that officers had indicated in their statements.
I'm asking you to accept that that may be the case, but there are still alternatives available, I'm suggesting,
I think that
even
could
if there was that fear.
Yeah, I think it could be, that would be an alternative. I don't think in this situation, though, and I don't know if the officers were questioned on that, but certainly part of that would also be officers providing, for want of a better term, security for the officers who are actually...
That's a potential. I think we had at least
Yeah.
5 officers
Yeah.
at the location, though.
It's probably difficult for me to answer that question in terms of is it an alternative, because it would probably have to be down to those individual officers' thoughts and feelings at the time. If this was a situation where similar circumstances but without that level of concern on the officers, then certainly it would be quite reasonable for 5 officers to pick the person up and assist them into the back of the vehicle. But given
It's a potential alternative, you'd agree, though.
potentially, yes.
Yes. And another potential alternative, although it doesn't address the dragging issue, is to ask his mother, who was nearby, to accompany him in a vehicle that was leaving the scene.
I think in these circumstances, I don't know if that is a alternative that I would possibly have considered, given the whole nature of the incident.
Why not?
I think it seemed to me it seemed quite dynamic.
Certainly we have, of course, a person who's suffering a near fatal injury at that point, and his mother is outside, very close by. It's certainly a possibility that officers could
I think
have
so, yeah.
included a
Potentially,
family
yes,
member.
yeah. But I think, again, I suppose I wasn't there, so I don't want to put my words in the officers. I think it's a possibility. I think there are also some concerns in terms of risk in the type of vehicle that we use, but also I'm not sure. Other than obviously you want to allow the family of the person and the person, you would hope that presence would be comforting for them.
Indeed.
But I'm not sure what the officers, while Kumanjayi was in the back of the vehicle, were actually doing, and whether that would have been an impediment. I don't know, so it's hard for me to answer that.
All right.
There's a second vehicle.
Indeed. There are more than one vehicle
Yeah.
outside. I think, in fact, it was 3 vehicles ultimately.
Oh, okay. So if you're asking me,
logistically
if you're asking me, is it possible that Kumanjayi's mother could have gone in one of the other vehicles, not necessarily the vehicle he was in? I would say that indeed is certainly an option.
Yes.
Sorry, I probably misunderstood, thinking that you would want mother to be actually in, perhaps in the vehicle where he is being treated.
by
Yeah,
officers. Okay.
my apologies.
Either that or in the front of the vehicle where he was in the back of that.
Yeah, I'm not sure what sort of vehicle it was. So
Now, moving to the issue of directions to these officers not to speak to each other about events, which you deal with at pages 94 to 98 of your report. Now, you've made some comments that those directions ought to be emphasised in the general orders applicable to deaths in custody, correct?
yes,
Now, of course, that obligation was already contained in 12.3.3 of the Deaths in Custody General Order. That's right, isn't it?
yes.
You found, as part of your investigation, you've mentioned at page 96, that there was no evidence there was any direction by the Alice Springs investigators who arrived in the early hours of the morning to those witnesses who were at the station to separate or not speak of the events, correct?
From my recollection, I think Sergeant Leith Phillips had given some instruction around separating of witnesses,
Indeed.
but certainly after interview, I don't believe in any of the interviews there's any direction on the part of the investigators to remind members of their obligation not to confer.
Yes, well, if I can just press a little more on that. Detective Acting Senior Sergeant Phillips indicated that he had notified that to the Alice Springs investigators who were travelling to Yuendamu, correct? And I think we've heard evidence from Mr. Panuto that he had directed Mr. Phillips in that regard. However, none of that actually occurred on the scene in Yuendamu. That was
No, I think that's a fair assessment. I wasn't aware that Mr. Panuto, until he gave evidence, had contacted Mr. Phillips. Certainly in the information I read, it seemed that information to the investigative team was from Acting Senior Sergeant Phillips.
yes.
But certainly, as I just alluded to, from it appears when you read the interviews that further information or direction isn't provided.
And in fact, you make that finding at page 96 of your report, that you have been unable to locate any evidence to indicate that had occurred.
Yes, there was certainly lots of discussion about it, but it doesn't look like the... I think, as I say in the report, there was certainly, at times, comments from Mr. Wurst, Panuto and Commander Tonkin, but it doesn't appear that those, I guess, thoughts that it actually was implemented, yes.
Indeed. Do you know whether there was any consideration of remedial or disciplinary outcomes in relation to the lack of delivery of those directions to the officers who are on the ground?
No, I don't.
That is, you don't know whether anything has happened.
No, I don't know. Yeah.
Not that it has not happened?
No, I don't know if any disciplinary action, remedial or otherwise, has been taken in relation to that.
And then similarly, a similar question in relation to the evidence that was unearthed about the social barbecue that happened in at Mr. Rolfe's house on the 11th of November. Do you know whether there has been any remedial or disciplinary outcomes from that event?
No, I don't.
Now, we've heard evidence that Mr. Rolfe's phone contents were only downloaded quite late in the investigation. And that would have been after you were appointed to the Coronial team, which was, I think, August 2020, and then the phone download occurs and is disseminated to Northern Territory Police in November 2020.
Yeah,
Is that according with your recollection?
Seems right. I must say I'm a bit fuzzy on dates.
That's
but
okay.
yeah.
But do you recall that there was a delay in the download of the telephone from Mr. Rolfe?
From the time of its seizure, do you
Yes,
mean? Or?
from the time of its seizure.
Look, to be honest, I wasn't aware. I was aware the phone had been seized. I didn't know what date. That was more from the criminal side of the house. I was made aware by my team at the time that the contents of the phone had been downloaded and accessed.
Yes, and in fact your team went through the actual contents of the phone in order to ultimately provide some of that material to Professional Standards Command to consider disciplinary responses, didn't they?
Yes, that's correct.
And Police Officer Brett Wilson provided a statement in the criminal prosecution in March 2021 to an officer called Greg Keane. Do you know whether that was part of the criminal investigation or part of your team, the Coronial?
That was the criminal. So
I see.
from my perspective, and it was Senior Constable Kingston who was our, I suppose, phone guy, and my direction to Tim after being made aware of one particular item on the phone that constituted a potential breach of discipline was to do an analysis of it and identify matters that might be relevant to the Coronial inquest.
Yes.
And as a result of receiving those and reviewing those, I then provided a report to the Professional Standards Command.
Indeed. Now, so did you then yourself become aware of the kinds of messages that have been the subject of evidence in this inquest?
Yes.
Extremely racist, misogynistic and other kinds of concerning behaviours being revealed in those text
Yes,
messages.
and as a prescribed member at the rank of Commander, that is why that report was drafted and forwarded to Professional Standards Command for further investigation of those matters.
Thank you. Now, they're not set out in any detail in your report, the content of those text messages.
No.
Do we take it then that when you were making some preliminary comments about systemic racism and cultural bias, that they were not taken into account when you were reaching those views?
That's a good comment. I'm not sure that they were at that time because it was very specific, I suppose. For me, we had got the information. It was always going to be attached to the brief. I have to be honest, say we didn't do in my report, I didn't address those things particularly. But by the nature of some of the text messages, as we now know, I think it was pretty obvious that they had racial connotations to them.
Certainly. And may well be relevant to any findings in that regard by Her Honour, looking at this in more detail.
Yes.
Now, do you know whether any disciplinary proceedings were either recommended by your office or referred to professional standards in relation to other individuals involved in those text exchanges?
So I actually didn't make any recommendations in relation to, other than, I suppose, in relation to Constable Rolfe. I advised that there were elements that may constitute breaches of discipline, and the whole package was referred to Professional Standards Command to review all of those.
Holistic.
So in my mind, Professional Standards Command would then probably pick up some of those other members who have participated in sending those types of messages.
That would be your expectation.
Yes.
Now, your evidence before about providing a final report directly to the coroner, I appreciate. Did you provide any draft reports to Northern Territory Police Force in advance, though?
I think I did very early in the piece a document that we called the consultation draft,
I see.
That was again firstly provided to the coroner. That was at the request of the deputy coroner, who just wanted an idea to see where we were, what we were progressing.
Did that also go to Northern Territory Police?
It did after the coroner had been given his...
Permitted.
Yes.
And then, I'm sorry.
No, go on, go on.
And then is there a process where there's response given to you before you finalise your report?
Not from the Northern Territory Police. That only went to Mr Antisich, who was my direct report from the police line.
Yes.
I have to say it was a document really that didn't have a lot in it because there were so many areas that we were still developing. So I
There's
think...
not a lot of commentary in it, it's more factual.
Yeah, so it was really about the facts, the initial facts that the coroner is required to address in relation to death and the like, not so much the more systemic stuff.
And so would you say then that there was no input from Northern Territory Police outside of your command into the substantive commentary recommendations contained in your report?
In my report, there is no... actually, no, I'll correct that. In the report, there is a paragraph, I think, that talks about bias towards, in favour of Constable Rolfe.
Yes.
When I provided my report to
Mr.
the
Antisich.
coroner, and then to Mr Antisich, Mr Antisich contacted the office of the coroner, I believe the deputy coroner, Mr Calvin Curry, and requested that certain elements be, in relation to that paragraph, be included in the report. Mr Curry contacted me and advised that he thought that was appropriate, and those elements were for investigation post. So that's, I think there's 4 or 5 dot points.
I see. So I'm clear what process you're describing. You're describing matters that were contained in your draft report relating to your investigation of whether there was any...
No. They were absolutely matters that we hadn't covered in my draft report.
It was a request that you investigate any concerns about bias towards Constable Rolfe in the course of your investigation.
Yes.
I see. So it's a request for more information.
No, I probably need to re-clarify it. If you go to my report, there's a paragraph... Oh, now I've got to find it.
Your Honour, I note that my 20 minutes is up. May I have leave to continue?
Sure. Have you got much more?
I do have some more, but I also understand that Mr Bowe may not have any questions if I've covered all of the areas for the family's perspective.
All right, Ms Moran.
If there's no objection, Your Honour, I also have a hard copy.
That might be
happy
easier
to
for
read along. There are some markings, is the only thing.
Might be easier for you.
Yeah, absolutely. I'm sorry, I'm not very good with this flashing through the screen, Your Honour.
There's not much in the way of marking, and I'll remove the post-it notes.
Thank you. It's at page 168.
Yes, under the heading bias in favour of...
Yes, that's correct. So how that became to be included was after my report being provided to Mr Antisich and the coroner, Mr Antisich contacted the office of the coroner and requested that paragraph in its entirety, consideration be given to including that in the draft report. And the coroner advised that he thought that was appropriate, and so
Yes.
it was placed
Is that
in
the
there.
subject heading be included
Yes.
rather than the content?
The subject
Which is
heading
yours.
and the content is not mine. The content is actually Mr Antisich's as well.
I see. So Mr Antisich led to the addition of material, but is your evidence that there was no deletion from your report as a result of any
Absolutely not.
consultation with the Northern
No,
Territory Police?
the only change was that one, and again, not to me, directly to the office of the coroner.
Thank you. Now, you've made some conclusions and considerations about changes to OSTT training
Yes.
to have a greater emphasis on de-escalation and tactical withdrawal. You recall that aspect of your
Could you
report?
tell me what
Page
paragraph?
119 to 120.
Thank you.
I'm not going to take you to the detail of it, but I wondered whether whether those opinions are your opinions. That comment and recommendation.
Page 119.
119,
Oh, yep.
and then it finishes over the next page.
Look, those comments are my comments, but they are probably taken from my reading of a document produced by Queensland Police, and I think I identified in the
You
report
referred to that, yes.
that on reviewing this material and reviewing that document, there were some similarities in relation to the issues such as de-escalation and the like.
Yes.
Um,
And so
on-
to do that, you're reviewing the training materials yourself, the Northern Territory Police Force training materials, in order to form those.
I probably base
Yes.
mine more on the use of force reviews and everything else that I reviewed, not so much the
From
training
Mr.
materials.
Is that from Mr. Barham and his report in the criminal proceedings?
Yes.
I see. Did you ask Mr. Barham his views about the lack of emphasis on de-escalation and other alternative measures to avoid uses of force?
No, I didn't. As I say, it's a consideration.
Yes.
I found in my experience, there was quite a lot of commonality between some of the outcomes of the Queensland review and the
you're
issues
speaking
we were
about
reviewing.
a coronial inquiry that was into police shootings of mentally ill persons, I think.
I referenced the document. It's the QPS Violent Confrontations Review. It's an open source document on the internet.
Thank you. Do you know whether your commentary about that in particular has been taken up by the Northern Territory Police Force?
Look, I'm not aware. I think Mr. Smallpage will probably give evidence on that.
Thank you. Moving to complaints, and I appreciate that there are others who will speak of it, so I will try to be as brief as possible. But clearly, as part of your responsibility in the coronial investigation, you did take on board identifying any disciplinary breaches that you considered were available from the evidence that you gathered, correct?
Yes.
And you referred those to the Professional Standards Command where suitable.
Yes.
And it was also part of your purview to identify any systemic failures that might be revealed, particularly given the extent of prior matters we have here in relation to Mr. Rolfe.
Yes.
Now, you've obviously made recommendations for processes of detection of concerning behaviours and supervision of officers to be improved. Clearly, it's a very complex area, correct?
Yes.
And you'd expect that such improvements would take into account comparative analysis, academic analysis, to try to come to a position about best practice in dealing with police misconduct.
Yes.
Now, similarly, you'd expect that such processes to be effective in the Northern Territory would also need to identify and address the development of racism or racist attitudes amongst the force, correct?
Yes.
Now, as part of your investigation, you found limited records on Mr. Rolfe's My Career profile reflective of that extensive past conduct. Can I just ask, My Career profile is an internal record for Northern Territory Police Force?
Yeah, so my career is, the acronym is quite suitable. It's a system used by Northern Territory Police, I suppose, more as a career development system.
Tool.
So at each level, a direct supervisor every year will have a conversation with their subordinates in relation to some elements of performance, but it's not a performance management tool. But certainly, you know, what is their career progression? Where do they want to go? So at commander level, obviously, either the deputy commissioner, assistant commissioner, or commissioner meets with you to discuss what your performances have been and those things.
Is any component of that supposed, ordinarily by protocol, required to include any negative aspects of a person's career?
Negative performance, yes,
Yes.
and how you would go around addressing that. So that's in a I suppose not a disciplinary space or not a. It's a very informal.
Can I ask why not? You've made some commentary about the difficulties where there are records kept in different areas.
Yeah.
Do
So
you think my career is the place
No,
where
I
all
don't.
of these matters should be
I
held?
actually think
And if not, where? Sorry.
no. We have a system called IA Pro, which sits within our Professional Standards Command.
I see.
So that is a system where everything to do with the issues you're talking about in terms of discipline, performance management. It's a hard one because it sits in PSC, so it does sort of sit in a discipline, but performance management, even though it might not have a disciplinary outcome, can still sit in there. And certainly prior to leaving the police force, my view is that is the system, which is better used because you can then have everything in it. So I think about prior to leaving, we established a failed prosecutions model just to look at why some of our prosecutions at the lower level were not failing. And as a result of that, where either practices or poor results by members, they would be given a blue team reference to their supervisor, identifying that in this particular case, this matter might have been lost because notes weren't taken or whatever. It wasn't a breach of discipline, but it was remedial action. So we're actually then recording remedial action. That, in my mind, then is a rough basis of how you could then start to get a picture of a member.
I see. And that process that you've just described, is that one which has been incorporated into the IA Pro
IA Pro is a system set up for that. So traditionally it was brought to manage our complaints against police, but it has the capacity to do that. Or it certainly did at one stage. I don't know if it still is.
Is it held only by Professional Standards Command, or is it accessible by, for instance, supervisors?
It can be made accessible. At the moment it is. So how it works is if I can be given a link into a particular part of it. So the integrity of the system is maintained, but links can be provided to access, and I'm sure that access can be broken down to other areas.
You'd agree, wouldn't you, that if a sergeant or senior sergeant or even higher up is actually reviewing a member's conduct in relation to a complaint, that access to IA Pro to know the history of any complaints or issues that have been raised in the past should occur? Yes. Sorry, you have to verbalise.
Yes, and it's been a while since I've actually had to review a complaint, but at the moment, I think where there is a disciplinary history, it is provided, but we have to be careful too that it is a history, it is considered, but it isn't necessarily, shouldn't form the outcome in terms of, but where it's relevant, it can be provided by PSC.
All right. Do you know whether there's any requirement for any officers reviewing conduct of their inferior officers to actually look at that history, to access IA Pro?
I don't believe there is. I'm not sure what the general order says. It might say to do that, but I'm not sure.
Thank you. Now, from what you've set out in your report, you seem to have identified a number of systemic factors that may have hindered the force's review of use of force incidents and complaints. I'm seeking your opinion on the most significant ones. I have some ideas from your report, but can I suggest one at least, that is the statutory time limitations in the police administration?
Can you take me to the page? Sorry,
Look, this is a summation I'm drawing from the review that you undertook in your report of the past incidents involving Mr. Roth and what outcomes we see coming from those issues. The first question then is, did you yourself identify some systemic breakdowns in dealing with complaints against Mr. Roth?
I'm not sure if I actually looked at the outcomes and resolutions of those complaints, to be honest.
You made recommendations that it should be reviewed, but you didn't specifically form any opinion about
No,
why there might have been some breakdowns.
Yeah, I didn't go into that extent.
We might make some submissions about that then. In your report, you've produced graphs. It's at pages 29 to 31. I don't want to take you to the detail of that, but I'm just asking how you produce them. Is that from the IA Pro system that you were just speaking of?
No, I have to again thank Senior Constable Kingston for the laborious task, and I think I addressed this in around the use of force about how records and things are maintained. So what I tasked Mr Kingston to do at the request of the coroner was to try and build a picture of use of force and put some rigours around it to give an indication to the coroner of what that looked like. So all of that is manually obtained from use of force data.
I see. So he had to physically take a very lengthy process of interrogating that information in order to reach the graph data.
And further complicated by, I think as it's been given in evidence previously, that use of force, when you look at promise, you may not be the person who is the user of the force, but you might be tagged in the promise job if you're present when the force is used. So
it's not completely...
it's not push a button and out comes a wonderful report. It's very laborious, and I think I put in there that there is that should, as a system to allow that to happen, should be looked at.
Now, Mr Pollock indicated in evidence in this inquest that he thought that the IA program could be utilised to greater effect as an early intervention tool to identify trends concerning one particular officer or even a cohort of officers. Do you agree with that?
Absolutely.
And you'd also agree that that would be a very useful thing for the force to have accessible to it?
Absolutely. I mean, it can be... look, it's a great way to be across those things, and even if, just to give you an inkling or an opportunity to address things before they get to that critical point.
Now, that would identify perhaps higher numbers of use of force or recourse to use of force options, correct?
It would depend on what parameters you put around it, but even if you'd have to build the system to look at what that looks like. So it might be that you have an officer who has 30 use of forces, and then that gives you, if you think that's a high number in a week, for example, depending on what their duty is, you can then go in and look at those things. So I think it provides triggers for you to then look. A flag, yeah. I think Scott used the term red flag in his evidence. So I think, it's a red flag system.
But that process won't occur unless there's a reason to look into that particular officer that's identified by someone?
I'm not sure how IA Pro intertwines well with other systems, but I'm not sure if the technology, so you have to excuse me, in the perfect world, what you'll probably have is where the use of that IA Pro system talks to the use of force reporting system, so you would have those reports there, and then you could literally, if we print out, you might have those numbers, and then if you've got, Dave Proctor's had 25 use of forces in 3 days.
There's a prompt of some
There's a prompt,
kind.
yes.
I see. Would that program identify things such as the development of racist behaviours, for instance?
If they're reported, yes.
Do they need to be reported under that specific complaint mechanism that deals with, equity, equality?
It depends on the nature of it. Equity and diversity policy is very much an internal structure. Obviously, if that is, from my understanding, prior to I left, if that was an external complaint made, then obviously that sits under the professional standards ombudsman type situation, unless it can be dealt with by the complaints resolution complaint method.
Now, you noted at the time of your report that no disciplinary process had been applied to Mr. Rolfe except for his suspension upon being charged at the time of your report.
Yes.
And are you aware...
I think it was no disciplinary outcome, not no
I see. No outcomes.
Yes,
Correct.
thank you.
Thank you for that correction. Are you aware now of the outcomes in relation
No.
to Mr. Rolfe? Are you aware now whether there has been any disciplinary consideration in relation to other members of the IRT who attended on the 9th of November in Yuendumu?
No, and as I've been out of the police force for 12 months, I wouldn't expect to be.
That's okay. What about the supervisors of Mr. Rolfe? Do you know whether there has been any?
Same answer, as I say, it's now been 12 months since I left the police force, and I'm not aware if any has been taken or
My
not.
final issue to raise with you, Mr. Proctor, is you acknowledge in your own investigation that your investigation of issues of systemic racial bias was rudimentary, correct?
Yeah,
And so,
absolutely.
of course, it's anticipated that others may be in a better position to investigate those matters following the evidence in the criminal trial and before Her Honour in the coronial proceedings, correct?
Yes.
Nevertheless, you noted at page 167 that there were indications from your review that the deployment of the IRT and the actions of the IRT in the community of Yuendumu did discriminate or disadvantage in a systemic way Aboriginal people.
Yes.
Would you agree then that there are indications of systemic discrimination or disadvantage seen in the decisions of the police after the shooting, namely the dragging of Kumanjayi, the not using expired air resuscitation techniques in relation to his resuscitation, not engaging with the community or Kumanjayi's family when they're outside the police station, and the ruse that has occurred in terms of misleading his family and community about his condition? Would you agree that there are some indications of systemic discrimination or disadvantage in those actions as well?
No, I don't think I can agree to that principle. No.
You noted in your report that improved cultural awareness training and had been certainly a focus of the Northern Territory Police Force, including the establishment of the Community Resilience and Engagement Command. Would you agree that whilst improved training of new recruits is an absolute must, it would be equally important to improve the cultural competency of members of the force who have been in there longer?
Yeah, I think in my report, one of my considerations is that an induction package be developed for each station, and I base that on my experience when I first joined the police force. I think I was 22 when I went to Harts Range. My background, I was born in the UK. My parents emigrated to Australia in 1981 and I moved to the Territory in 1987. I'd never met an Indigenous person. In 1990 I transferred to Harts Range and had the great fortune to work with Kumanjayi Walker, who was at that time a police tracker. And
so you arrived at that station as a young recruit, and so what process did you go through to try and develop the sort of
our training? I recall our training. It's strange the things you remember was from a gentleman named Mark de Graaf, and it pretty much consisted about the kinship system. With Lindsay, I think to me it's, I don't want to sound dismissive, it was common sense that my upbringing was completely nowhere near anything that I was experiencing in the location of Harts Range. And he was a great mentor. He was a strong leader in the community, and through his guidance and advice, I think you got an appreciation of the difficulties of living in community, the benefits of living in community. Very foreign to me as to, in all the communities I've worked, and particularly at Harts Range, speaking to some of the young girls there and saying, what's your inspiration for your future? And I think that's when you start to get an understanding of how important the land and the culture is.
Well, it's utterly important, isn't it? For police officers going into these communities to be able to have any real positive effect.
And so for me, I suppose that was my consideration of I was part with Commissioner Chalk, who was Commander Chalk at the time, in the development of the ALO program. He was Assistant Commissioner Alice and I was in Catherine. And we saw it as a great opportunity for members of the community who might not want to be police officers or because of the pressures there, to assist our officers in getting a greater understanding. And I suppose that's where my recommendation there comes from, and I'm aware that the CREC We're still developing that, or might still be even developing that now. I think there's the broader stuff that you can train to recruits, but then when you go into community, to me, the idea of a fit-for-purpose induction package, and not, fill out your 30NA receipt book or whatever, but about who is who in the community, what are the community issues, what's the history of the community. So in this inquest, there's been lots about Yuendamu, and I understand that, but when you go to Borroloola, there is historical history, and then there is more recent history that still raises itself in terms of terrible events that occurred within the community itself. I think that's where I was coming from.
Thank you. I won't tax you on all of the details of that because there's obviously a whole lot of complexity and detail there that other witnesses are also speaking of. My question was really designed to try and capture officers who may have been officers for some time who have missed the benefit of those more improved programs of cultural awareness. Would you agree that there might be a benefit in rolling out cultural awareness training to existing members of the police force?
Yeah, and I think you've had evidence to that already. Yeah.
And then finally, would you agree to that issues of racism, whether systemic, conscious or unconscious, is something that requires continued, repeated measures and attention brought to bear in training, in continual training and in continual vigilance from supervisors to check against negative attitudes and experiences occurring?
Yeah, I think you have to have systems in place to ensure that when those things start to occur or become present, that one, you can identify them, and two, that you can assist, whether it be through development or whether it is through some punitive measure, depending on the level of it.
Thank you, Mr. Proctor. Thank you, Your Honour.
Your Honour, there is one issue I wish to interrogate, if I may.
Yes, Mr.
Mr. Proctor, my surname is Bowe. I appear with Ms. Bowe for the Walker Lane and Robertson families.
Good morning.
You would accept that when a police officer is charged with the offence of murder, that is probably the most serious investigation that the police force would be undertaking?
I think murder is any serious investigation, but certainly from the police force perspective, yes, because it isn't just about the offence of murder, it's also about where we are now, the systemic issues that come up, the systems issues that go along with that.
I guess I'm focusing on the need for there to be utter integrity in the way in which evidence is put together in the prosecution of a member of the force.
Yes.
To that end, when a police officer is charged with murder, of particular focus for the jury is the state of mind of that member, correct?
Yes.
And particularly looking at the defence under Section 146B, which brings into it the issue of good faith and reasonableness of the actions.
Yes.
Critical to placing evidence before the jury on those issues is evidence of the member's previous actions and statements which may inform an assessment of the state of mind.
Yes.
And you would be aware, for example, of the desire at times for prosecution to place evidence of tendency or coincidence before a jury.
Yes.
In this case, we are aware that in January 2022, an application was made in respect of some evidence concerning the issue of tendency. You're aware of that?
I believe so, yes.
Yeah. For example, as I read the trial judge's ruling, there were 2 text messages. I think one was an Instagram post, but there was 2 communications that were put before the trial judge to determine their admissibility on the issue of tendency. Correct?
If you say, I'll have to say I haven't read the trial
Take it
transcript.
from me
Yes.
that there were 2,
If that's
others
what
will correct
provides,
me.
I'll agree. Yes.
One matter that has arisen in this inquest is the circumstances in which there were other evidence that may be admissible as tendency, which was not argued before the trial judge. You understand?
Yep.
You spoke, and I won't adopt your word, that part of your assessment is looking at failed prosecutions. I'm not suggesting that an acquittal is a failed prosecution, but it is of interest to the family as to how it is that not all of the evidence in the hands of police, whether they be coronial or criminal investigators, may not have been considered to be placed before the trial judge for argument as to admissibility. Do you understand?
Yes, I understand where you're going.
Because we do know that one of the reasons given by His Honour was the temporal connection between the events relating to those text messages and the events of the 9th of November. Do you understand?
Yes.
What we have now seen from work done by counsel assisting team is uncovered quite a few more communications. You're aware of that. They've been referred to as racist and the like. You would have seen reports about that.
Yes.
I'm not as interested in the racial aspects of it or the derogatory aspects of it, but there is indications that from these text messages that there were actions and thoughts held by Constable Rolfe which bear greater examination. For example, his use of force in previous policing actions. Do you understand? What I'm having difficulty finding, because not all statements that pertain to this issue, for example, from Mr. Kingston, you said earlier that Officer Kingston went through the phone for the Coronial team to look at relevant evidence. You did say that just earlier, didn't you?
To look for information, I shouldn't say evidence, information that would be relevant to the coronial, I think is what I said.
Well, whether it's relevant
information or evidence, but relevant to the coronial.
Sure.
Yeah.
I guess the difficulty I'm having at the moment, and we'll pursue this in other ways, is that as I understand it, the digital forensic examiner, William Pham, provided the extraction of what was on the phone in a readable format on the 19th of October 2020. Does that generally accord with your recollection?
I can't recall because I don't think the digital extraction was provided specifically to the coronial inquest.
Well, can I just stay away from this distinction between coronial and criminal just for the moment? And the reason I do that, before you roll your eyes, is that we've been provided an updated crime, homicide and serious investigation general order, which has recommended, or which has stated, that there should now be one commissioned OIC responsible for both the criminal and coronial aspects of an incident.
Yes.
Okay. And there's great merit in that, if I may say. So if we get to just ensuring that we have a process going forward, that things don't fall through the gaps, as it were. So when you make the distinction between coronial and criminal, I'm asking you to look ahead in a sense to assist us, given your experience and knowledge of how police obtain information. What we don't have at the moment is any reliable record of what police provided to the DPP as being the relevant material obtained through examining the phone. Do you understand?
Yep.
With the dates, what we've got is that the 19th of October 2020, which is more than 12 months before the commencement of the trial, it's about 14 months, what we don't know is what information was provided to the DPP by Northern Territory Police. Have you examined that issue at all?
No. That was very much at the time in the criminal side, so I think you'll see in our report, I don't think we had full access to what was provided in the final brief.
Yes.
When I say access, we had access to, both teams had access to the information drive, so they could see what we were doing and we could see what they were doing, other than, of course, the reports. But in terms of your question there, no, I don't have any visibility of that.
The families, and I guess the community in which they live, and the entire Indigenous community may be perplexed how evidence which seems to be potentially admissible was not used at the criminal trial. Do you understand? How do we address that? I well appreciate as a lawyer that the process of inquiry in an inquest is different in determining the admissible evidence at a criminal trial. And we have to accept that that system is one where the criminal trial will precede, usually, an inquest. So it may not be of any surprise that some evidence comes out after a criminal trial. The difficulty...
I'm not sure where Mr. Bowe is taking this line of inquiry with respect to your task in determining cause and circumstances of death and recommendations as to how the criminal justice system might work differently. I'm just not sure where this line of inquiry goes. It seems to me it's traversing how the prosecution was run, what forensic decisions they did or did not make.
I think it's more on the investigation side and the sharing of information, but I'm not sure.
Your Honour, we accept that nothing can be done to traverse the verdict, and none of my questions are intended to promote a submission to that effect. The matter of concern is that there is evidence which would...
Sorry, yeah, I understand what your concern is, but what are you seeking from this witness
Yes.
in relation to that?
Yes. I'm seeking from this witness whether the recommendation or the clause 11 of chapter 4 of this report sufficiently addresses...
Which page is that? Do you have
Take
any
page
idea?
32 of 42. No, it's not this man's report, it's the report that was tendered 2 or 3 days ago
Oh, okay. Thank you.
of the changes to the investigation.
Right, so the new
Crime,
proposed
homicide
general
and
order.
yes.
Draft general.
And I anticipate that submissions may be made by the police interests that this has been an adequate step to address the issues that have been revealed in this inquest, and I'm wishing to ascertain from this witness his view, given his experience and his knowledge of the entire brief,
So
as
it's
to
clause 11, chapter 4, so you need to actually look at the chapters.
chapter 4.
Page numbers.
Which dot point is it, if you don't mind me
It's
asking?
page 32 or 42,
Yep.
chapter 4, clauses 10, 11, 12,
Okay. Yep.
13.
And sorry, what was the question again?
The question is this. In the following page, you'll see that there's a structure
Yep.
in a diagrammatic form. There is a challenge when there are different responsibilities, whether it's headed by one officer in charge, when the police force continue correctly to distinguish between criminal and criminal aspects of an investigation. So I'm not cavilling with that as a concept. What I'm concerned about is that this need for time sensitivity in relation to criminal prosecutions and the need at times to silo particular evidence which is of no use in one or the other. I understand all that. Do you think that there is enough known and thought by the people you worked with and who are in the system still, by merely having clauses 10 to 13 and the structure in 16 to ensure that all relevant and potentially admissible evidence is provided to the prosecution agency? And how do we ensure some transparency on review about that, so that you do not attract the criticism that even though that there is a system which has resulted in a verdict, that the Walpole community have still not seen in their eyes any justice in the outcome?
I'll probably break my response into two bits, if that's okay. I can't provide you any enlightenment in relation to what evidence was provided to the DPP or decisions around what was to be put forward or what wasn't. In relation to these dot points, I think this was, and I think I addressed it in my report, this was a very unusual circumstance and a very unusual structure of having two separate silos with two separate officers in charge.
That's even leaving aside personality differences.
Yeah, forget the person. I'm just on about the structure, because normally, I wouldn't say normally, in this was a unique situation, so we don't have a lot of these types of incidents, fortunately, and I'm not, but I think what occurs then is someone has to be the deconfliction point of, and understand the priorities of, as you say, what is going to be produced, what's in the coronial, what's in the criminal. I suppose I use the example of, I think, the statements that were taken or weren't taken. From the criminal perspective, that might not seem important. I'm talking about Commissioned Officer's statement, but from the coronial, it's extremely important because it goes to the integrity of the investigation and integrity of the office of the coroner.
Yes.
I've provided some comments in relation to that from my experience. That is about the role of any officer in charge, whether it's of both or whether you choose to separate out, but of both, if you're covering both these things, is to prioritise those lines of inquiries and those evidence. I think that's the key thing, is understanding your role in relation to the criminal investigation and also the role in relation to the coronial investigation. I don't know if that answers your question, but I think that's the important part.
Yes. You haven't undertaken any review, and I know you've now retired. Do you know if any review has been undertaken to see what... I'm putting to you that from what I can see, there's certainly evidence of a very similar character, namely text messages coming from the phone, which does not seem to be placed before the trial judge.
Yeah.
And there are several explanations for that, I'm sure. But to the extent, has there been any examination of what in fact was provided to the DPP?
My short answer, Mr. Hayes, I don't know. Certainly not prior to my retirement, and I don't know if that's been has occurred, because obviously the trial
Occurred after you left.
Occurred after I left.
I understand. I think Dr. Freckleton wishes to... I'm inviting you to... No, I'm inviting you to...
Your Honour, in our submission, this is really going beyond the parameters of what can reasonably be looked at by the court. The interaction between police and the criminal prosecution team at trial is not something that reasonably falls with respect to your scope of inquiry. We've held off interrupting another friend. But one, the issue on itself is beyond the proper scope of the inquiry, and two, this witness cannot assist you.
Yes.
Yeah, I respect that, and I will talk to Dr. Freckleton and perhaps see whether Mr. Smallpage might be in a position to, or somebody else might be able to provide that. And why I say that, I'm not acknowledging, but not arguing against the impropriety of re-examining the trial process. As Your Honour identified, it is a matter of concern for us that the systems in place will ensure that where there is evidence that some texts were considered and some were not.
I suspect it might be able to be resolved if you have a discussion with Dr. Freckleton in relation to the evidence that's going to be given by Mr. Smallpage. I don't know, but
yeah, I understand.
if it's a live issue after that, then we can see whether it's something that I need to consider further.
Yes, thank you, Your Honour. Those are my only questions.
Yes, Mr. Bolton?
My name is Bolton. I'm appearing for the North Australian Aboriginal Justice Agency.
Good morning.
In your report, you touch on the wicked problem of racism.
Sorry, Mr. Bolton, could you take me to which
Yeah, it's
page?
page 168.
Thank you.
Where you described cultural bias and institutional racism as being complex, if not wicked, problems. Okay? And your opinions about racism and institutionalised racism very helpful, and one of the few formal pieces of evidence gathered, or opinions gathered, to assist the coroner in relation to this. But I was listening to your evidence when you're answering questions from Ms. Moreau, where you tended to limit your assessment of racism and the effect of racism to events that occurred up to the time of shooting the deceased, but not after he was shot. I want to ask you a few questions about the period after he was shot. But before that, Mr. Proctor, when you took over from Mr. Pollock and read his draft reports, did you notice that he had in his draft, or at least in one of them, a segment which was headed excuse me, the policing culture in Alice Springs,
Yes.
under which he expressed the opinion in the draft that by November the 9th, 2019, the policing culture in Alice Springs had degenerated into a state where unacceptable police behaviour was allegedly being condoned by supervisors, and there was more of that ilk. You
Yes.
remember?
Yeah,
that?
yeah,
You
I remember
didn't
it
put
quite
it in
well.
your report.
No,
You didn't cut and paste, nor did you address the policing culture in Alice Springs.
not in those words. I
Yeah.
believe I addressed it. So at the time that draft report was written, by the time I wrote this final report, we'd done a significant amount of work around the policy. So, for example, the whole IRT deployment and failure to comply with their SOPs almost at every level. The use of force audits, supervisor audits, and then also including some of the information Mr. Pollock had referenced in relation to the failures of the IMT in Alice Springs and the command management teams. I think in my mind that represented a broader example of the failures of the issues of the culture in Alice Springs and failures of managers to address those things.
Do you agree that by the time of the shooting, policing culture in Alice Springs was entirely unacceptable? Was in many respects unacceptable?
I think elements of it were, yes. I think it's hard to say the entire culture of policing in Alice Springs because that particular issue relates very much to the IRT. I would say, though, based on my findings of the failures to follow policies, the failures to undertake appropriate supervision of use of force, that the culture was inappropriate.
Mr. Andisic, who gave evidence here the other day, described the inability of the Alice Springs supervisors of Mr. Rolfe to deal adequately with quite regular use of force complaints generated by Aboriginal people, mounted by Ngarja, was, I think his words were, an abject failure, quote unquote, and, quote, corrupt, quote unquote. Did you read about that or hear that evidence?
Yeah, I heard about the evidence.
Yeah.
I agree with the abject failure. I'm not sure around his comments about corruption, as I haven't examined all of those things. Certainly on the elements I examined in terms of use of force, not necessarily complaints, I would say there were examples of abject failures on the part of supervisors.
Yeah, so the inquest has received quite a lot of evidence about individual aspects of Ngarja's complaints about Mr. Rolfe. And of course, you know that the coroner has received evidence about racist attitudes that he obviously held at relevant times, including at or about and indeed after the shooting of Kumanjayi Walker. That being the case, his policing methodology, his own policing methodology, and his exercise of use of force was probably in part a result of a number of things, and I'll go through some of them. Disregard for the Aboriginal people he's policing. Do you agree with that? I can take you to some of these comments.
No, I'm just, yeah. Look, I think on the evidence we've seen, I would agree with that, yes.
Yeah, well, you didn't see it though, did you?
Look, I've seen some of the footage,
seen
and
it.
I've reviewed some of the footage as part of the Coronial inquest, and on that I would agree, yes.
You didn't see the racist comments when you wrote your report. You hadn't.
No.
Seen it. Yeah. And another motivating factor, part of his essence, if I can be so unscientific, was the fact that he'd had military training. Do you agree? A get your man, focus-driven, act with one objective type of policing, right?
I don't know if I can, with any great gravity, say that they both correlate. I accept that he had military training.
Yeah.
I don't know if the military training was the sole factor in his essence as you described.
No, I'm not suggesting it was. I'm suggesting it might have been one of the factors that influenced the way he conducted himself.
I think that's hard for me to comment on. I did make mention in relation to elements of militarisation of policing, but I don't know if I could fairly answer that.
One of which, at page 136 of your report, is that, as one observer has noted, former military personnel bring important skills like teamwork, discipline and proficient use of weapons, but it's not easy for them to transition from warriors to guardians, right?
Yes.
And that might well be the case with this young man, right?
I think that assessment I would agree with. I'm not sure about the essence of
And do you understand that during the time that he was acting as a general duties policeman, not as an IRT officer, but as a general duties policeman here in this township, he was regarded highly by his supervisors because he was such a reliable, go get 'em and catch 'em sort of bloke, right?
Yes, I understand that.
And the fact that he was a racist was known by his supervisor, at least the IRT supervisor. You understand that?
Yes.
And the fact that he used racist and derogatory terms was known by at least a number of his general duties colleagues, right?
Yes.
His one-time girlfriend, also a police officer, expressed the view and stuck to it under cross-examination in this inquest that it was actually quite common for the people that she dealt with at a rank and file level to hold racist views like her boyfriend did. Do you understand that?
Yes.
Okay, so that is corrupt, isn't it? That is a corruption of the police force, isn't it?
I don't know if I would strongly use the word corrupt.
Well, why not? I mean, corruption is not just taking backhanders. If the police who are arresting Aboriginal people with excessive use of force, which is deemed to be acceptable, are actually racists, then there is something seriously wrong with policing in Alice Springs. Is there not?
Well, I think the proposition you put forward was corruption of the police force, whereas a lot of the information you just provided is specific to Constable Rolfe.
The problem is,
I'm not disputing that the systemic issues in the police force, some of which you attribute, some of the issues you attribute to Constable Rolfe may not be present in the police force, but I don't know if they're to the level that you have put forward there in terms of corruption.
Mr. Proctor, one of the big problems is that police in authority, one after the other, deal with these issues on the assumption that it's not widespread and that action should not be understood as necessary because it's bad apples that you're talking about.
I'm not saying that action shouldn't be taken. I'm not saying that it isn't. What I'm saying is that in the information you provided, I don't have evidence that every police officer participates or undertakes their duty in that way.
So, Mr Proctor, part of the dealing with institutionalised racism, should there be any, is for the police service itself to recognise it, right?
Absolutely.
And to admit to it, right? And if no admission is made to it, what do you think is likely to be the effectiveness of any attempts to clean up racist elements and racist attitudes in the police force?
I think there's a step before that, which is systems in place to identify it, address it, and perhaps then provide that acknowledgement.
Could you please explain how the police command can identify racism if no one owns up to it?
I don't think you're going to get too many people to admit to being racists. I think there's quite a fair amount if you look through history and issues in other countries where people won't admit to being racist. I think it's about having systems in place that identify some of those behaviours, similar to where we talk about the red flags, the early intervention, and I think it is an education process. It has to be that people identify those things, acknowledge that they're wrong, and you have a system which you have systems in place which make that a constant awareness within the workplace or within the police force.
In going back to the facts surrounding the death of Kumanjayi Walker,
Yep.
the failure of the police, in fact the decision by the police, not to tell his family that he'd been unable to be resuscitated. You described at page 104 as an appalling decision.
No, I think the reference I make, I don't normally use emotive phrases, or try not to use emotive phrases. That was one that I think that's in reference to the sequence where, is it Mr. Edwards, or the contact is made with a family member, Mr. Robertson, to advise him that medical treatment has still been undertaken, and then several hours later he is contacted to come to the police station and to identify Kumanjayi.
Well, whether it's failure to report, or whether or whether you're considering the broader deceit.
Yeah.
The deceit was appalling, was it not?
I think it's hard to say that it's appalling.
You did.
No, I said the contact to Mr.
Well, let's have a look at what you said. Go to page 104, please.
Yep.
Under the heading Comments and Considerations, you set out recommendation 19 of the Black Deaths in Custody Royal Commission and the Northern Territory Police General Order Deaths in Custody Investigation of Serious and or Fatal Incidents resulting from police contact. And you accept that pursuant to both, notification to a family representative of the deceased where appropriate, and the relevant Aboriginal legal service or other appropriate community organisation as soon as practicable is required, right?
Yep.
And then you state that there was 8 hours between the deceased's passing until Mr. Robertson was informed of the death,
Yes.
right? And you said that under normal circumstances that wouldn't be considered as soon as practicable, right?
No.
Then you point out that this wasn't a normal situation, right?
Yes.
And you speak of Acting Assistant Commissioner, as he was then, Travis Worst, who made the decision to delay the notification, and his concern about the safety of the police and health staff who were inside the police station, right?
Yep.
And you then said whether the decision to delay the notification to the family was right or wrong, it's difficult to reconcile given the competing interests of public safety and obligation to advise the family. The rationale of Mr. Worst is one that indicates it considered both factors and made the decision that he believed was best to prevent the further harm to the members of the community or those inside the police station. Then you said, and this is the relevant part that I was referring to, unfortunately, the way this decision was then executed can only be described as appalling. The failure to provide any response to inquiries made by family members 23:05 hours, followed by police contact and advice to family members that Kumanjayi was still receiving treatment at 7 minutes past 12, followed by police contact to a family member who's requested to attend the police station and then is told that he's deceased, demonstrates little consideration and compassion to Kumanjayi's relatives,
Yeah.
right? So that's what you thought was appalling, right?
The bit that I was referring to as appalling was actually the second part, not the first part.
That being what? The second part?
The second part, in terms of the failure to provide any response to inquiries made by family members, following and advice to the family members that medical treatment was still occurring at 007 hours.
No, it wasn't.
When it wasn't.
Yeah.
And followed by the police contact to a family member who is requested to attend the police station on an arrival is advised Kumanjayi Walker is deceased,
So you
and then
think
is
that's
asked.
the only appalling part that he was told at 4 o'clock in the morning?
I think that is the significantly appalling part.
What about pretending that he was still alive? Do you think that was appalling?
I think in the evidence provided by Mr. Worst that was one of their considerations. I think possibly other things could have done, but I wasn't on the ground.
Well,
I don't think it was great practice, and it certainly, in respect to the family, is something I wouldn't want to happen if I was a member of that family, or if that was in my family.
What about the deceit of pretending that Kumanjayi was being airlifted to Alice Springs for treatment? How would you assess that particular deceit?
Again, I think it's hard for me to answer those when I'm not the person on the ground. In the person reviewing it, I think in a perfect world, you would not do that.
We all live in an imperfect world.
Perfect world, yeah.
But
I think it's whether or not the rationale that they've provided in relation to the reasons for it is acceptable.
you see, you've offered opinions. You've come along here
Yeah.
as the man who's looked at everything up to the point that you issued your report. You've offered opinions. Here's your chance to express your opinion.
Yeah.
Put your colours to the mast, Mr. Proctor. What do you reckon?
Look, I think certainly in terms of appalling, which is for me a very strong word, when I read the information in relation to the contact of, I think it's Mr. Robertson, is that correct?
Mr. Robertson.
Yeah. To me, in my shoes, I just think that would be absolutely devastating. You're being told that he is being subject to medical treatment, and then you're contacted and asked to identify a deceased person. I think that is completely appalling. That should not have occurred under any circumstances.
Yeah, well, I directed you more specifically in the last question, and here's your opportunity to comment about what you think about the deceit of taking an ambulance to the aerodrome, pretending that there's an injured man in it, putting him on a plane that's got the Royal Flying Doctor Service badge on it, and leading everybody to believe that he was on his way to Alice Springs to get treated. How do you think? What do you think of that?
I think the deceit of the community perhaps was unnecessary in certain circumstances. I don't know if I would say it's appalling.
It's a mild criticism.
No, I think there's, well,
It sounds mild.
yeah, I think when you take into consideration the situation the officers involved were perceived, I'm not saying it's completely justified, there could have been other things, but you have to consider that in it as well.
So
In hindsight, would I consider that to be undertaken again? I would certainly say no, for all the reasons you have quite rightly raised. Whether they considered those at the time, I don't know.
the officers concerned, Mr. Worst and Mr. Nobbs in particular, have offered a complete explanation about why. And they have expressed the opinion that there was not one single Aboriginal person that was in the community that night that they could possibly trust with the truth, because had they told even the ACPO the truth, there would have been devastating and catastrophic consequences to human life, to property, the police station, not just in Yuendamu, according to Mr. Nobbs's fears, but a domino effect throughout all Aboriginal communities in Northern Territory, both in the desert, the top end and throughout. I put to you for your consideration that such an attitude is indeed an attitude that is based on race. That is, it is ascribing to every Aboriginal person the same characteristic, namely it's a threat to the police, every single one of them, tarred with the same brush. What do you say about this attitude?
I say, from my knowledge of their evidence and what was in the brief, those views were based on the experience of those officers.
Yes. So the fact that someone has experience in an Aboriginal community, you think it justifies, in your view, a conclusion that you cannot trust an Aboriginal person with sensitive information in the context of the developing situation such as it was on the night? Not one.
I wasn't there on the night. In relation to my own personal examples, and again, I wasn't involved on the night, and I don't have an understanding of who or what was in the community, so it's hard for me to say that I would say I wouldn't trust Aboriginal people. As I alluded to previously, my experience in remote communities, quite often I only had one person with me in many situations, and that was either Kumanjayi Walker or Noel Dixon, who is an Aboriginal community police officer.
Did you trust your
Absolutely.
black tracker?
I wouldn't call him a black tracker, I would call him an Aboriginal tracker.
Aboriginal tracker?
Absolutely. And every ACPO I have worked with, I have trusted.
Would you trust them with sensitive information that might cause difficulties to the police had it been used irresponsibly? Or was there a limit to what you could tell your Aboriginal tracker?
I think it depends when you say what sensitive information are you talking about. If, for example, it's hard for me to say because in those communities I wasn't dealing with particularly sensitive matters of a nature where I would think the information could not be passed on. So it would have to be extremely sensitive information for me not to share it. So if it was a covert investigation or something like that, possibly not.
What about information concerning the death of a person?
In my view, I probably would have a conversation with them and find out what their kinship pressures placed on them would require them to tell the family, because that's the risk, isn't it? If the information gets out, what is then going to occur from that? I don't know if that was done or not.
Well, it wasn't. I don't think any police officer in Unimur even knew what the ACPO's kinship connection was to the deceased. But no one asked. So would you regard those sorts of attitudes as attitudes that demonstrate that you deal with Aboriginal people as a group rather than on a case-by-case individual basis?
Sorry, can you repeat the question in relation to?
How do you think police should deal with Aboriginal people? Should they be dealt with
I think
an individual assessment?
no. I think Aboriginal people should be dealt with the same as everybody else, accepting that there are cultural and elements that you need to consider when you're policing and working and living in Aboriginal communities that you may not necessarily have to deal with living in a community that is primarily made up of Caucasian, European, English-speaking persons.
Mr. Proctor, have you seen the videotapes that were taken on a mobile telephone outside the
No,
police
I
station?
haven't. No.
Have you got any clear idea of exactly what was going on outside that police station in the crucial hours that we're talking about?
No, only from the evidence of statements that I read in preparation as part of this report.
Some of them are publicly available on the
Yeah,
website. Have you not had a look at them?
No, I haven't. I genuinely haven't. No.
Okay. Did you choose not to? Or
No, I just didn't. As
You
I say,
retired?
yeah. Look, give me clear. I haven't followed this religiously, watching every single second of footage. To be honest.
Yeah. I've got about 3 more minutes to go. Is that okay?
Yes.
So, just in relation to the idea of paramilitary police being used in Aboriginal communities, your report highlights that as far back as the Aboriginal Deaths in Custody Royal Commission, it was recommended that wherever possible that be avoided. The inquest has heard evidence from a senior police officer that paramilitary style immediate response team is the gold standard of policing that should be rolled out nationally, including in the Northern Territory. Do you agree with that?
No.
Why not?
The IRT was, well, first of all, when we talk about paramilitary or tactical type groups, the gold standard, for want of a better term, across Australia is police tactical groups, mainly because they all operate to similar standards under the National Counter-Terrorism Agreement. I was the commander of that area for quite some period of time. The IRT is was developed to provide a specific skills enhancement to Alice Springs for deployment to high-risk incidents where normal policing operations and tactics had failed, and the situation, so cordon and containment, where that had failed and negotiation had failed, and the situation was such that an immediate entry and action was required. I think to say that it's the gold standard is very hard when it's a, one of a better term, part-time unit that only has specific levels of training.
TRG, or properly resourced, properly trained response group.
It's their full-time job.
But in the Northern Territory, it's a bit hard to have one in Alice Springs.
Absolutely, and that was the reason for the development of the IRT policy.
So there really isn't much call for a TRG in Alice Springs, is there?
I think the difficulty with having a TRG in Alice Springs, and it's a concept that's been mooted many times even while I was the commander of that area, is deployment side aside, if you could have that capability here, great, because TRG are experts at command and control. They're experts at de-escalating matters, even though one of their primary functions is counter-terrorism and tactical assaults. The difficulty here is having all those resources, having that training, having the training to interoperability, because that's one of the key roles of TRG.
Would you agree that having part-time tactical police, for want of a better word, is likely to infuse general duties policing with tactical response group style techniques?
Yes, I agree that the training provides them with an enhanced level of skills compared to a general duties officer. However, the policies that were surrounding the IRT and their deployment should have prevented that infusion into general duties policing.
So should supervision.
Yes.
Right? And there are real supervision problems in the Northern Territory Police, is there not?
I think when you look at the evidence provided in my brief and the brief of evidence, there are supervision problems within Alice Springs, and I can't speak for the whole Northern Territory Police because I didn't look at the entire Northern Territory
We're
Police.
only concerned with Alice Springs here in this inquest.
Yep.
But certainly, as at the 9th of November 2019, there were significant failures in the oversight of ordinary constables in the execution of their duty here, right?
Yes.
In town, right?
Yes.
And it spilled into Yuendamu on this night, didn't it?
Yes.
That's all. Thank you, Anne.
We
Time,
will take the morning tea adjournment. O'Connor, sorry.
No
There's
problem.
some derivation, there we go.
Close enough, Your Honour. Mr Proctor, I'm appearing on behalf of Parampuru Committee, which is a committee of elders from Yuwindana.
Yes.
I just wanted to pick up on something that Mr Bolton was discussing with you just before the morning adjournment, which is the militarisation of the Northern Territory Police and the prevalence of a paramilitary mindset within the Northern Territory Police, if I can put it that way. In your 34 years in the Northern Territory Police Force, have you observed an increase in the militarisation of the Northern Territory Police?
Yeah, and I think I do talk to that in my report. Not necessarily in relation to our normal policing practices. I think militarisation of police, perhaps in Australia, but certainly in the Northern Territory, was increased after 9/11, where there was a significant national increase in terms of the counter-terrorism threat.
Yes.
And I think I also put in my report that as part of that, I think the Northern Territory Police is looking at the patrol rifle rollout.
Yes. Can I suggest to you, Mr Proctor, that's one of several ways where you might see an increased militarisation of the police force that you address in your report. Some of the other ways may be the high numbers of ex-ADF members in the Northern Territory Police Force.
Yeah, I think I talked to that in my report as well. I think we've got a chart in there that tells you how many ADF members we have.
You do, and I would suggest to you that it's over 26%
Yes.
of members recruited between 2010 and 2020.
Yes.
And you've already raised the military-grade weapons that have been introduced into the Northern Territory Police Force. There's also military-style uniforms, would you agree?
Yeah, I think in the 34 years we've had a transition from a khaki uniform to a blue uniform for cargo pants. Whether that was based around militarisation or the practicality of now police officers carry more because of vests and more accoutrements, certainly from my experience wearing what I would call dress trousers and a khaki shirt and a belt and a pair of handcuffs to police compared to today's uniform of cargo pants. I think the cargo pants are much more preferable, but I acknowledge that they do have a paramilitary look to them.
And I was in particular having reference to the use of camouflage gear, for instance.
Camouflage gear within the Northern Territory Police, though, is limited to TRG and, in this case, the IRT.
IRT as well, yes. Militarisation may also be reflected in the training and tactics. In particular, I'm thinking with relation to the IRT in this case.
Yeah, I think there's no disputing that, as I said before, the particular tactics, or I would call skill enhancements that were provided to the IRT are based around training that is provided to the PTG in regards to rapid entry for high-risk situations where normal policing practices and tactics have failed.
Yes, and what you say in your report, I don't need to take you to it, but you discuss the transition from a cordon and contain unit to the IRT, and you say the IRT adopted a paramilitary role focusing on weapons training and tactics involving green roles, meaning tactical observations in remote areas, and black roles, meaning tactical entry into strongholds, house cleanup. Do you recall saying that?
Yes, because that was a transition from the original cordon and containment team, which was very much Alice Springs based, as I say, to a skills enhancement where the enhancement was around, if required, if all normal policing practices in relation to a stronghold, for example, had failed and there was an urgent need to access the stronghold, they had that particular training, rather than in the situation of the Northern Territory where distance is problematic, having general duties officers with no training trying to undertake that type of entry.
Would you accept that the role of militarisation of the police force in the circumstances and death of Kumanjayi Walker was always a focus of the Coronial investigation? While you were involved in the Coronial investigation?
Yes, it was one of the areas that the coroner had asked us to look at in particular.
I'd like to take you to one of the annexures of Mr. Pollock's statement at 7-111A, which I believe the court clerk might have ready. 7-111A. And if we could go to page 89 of that document, please. You'll see there, Mr. Proctor, this is minutes of a JMC meeting, Operation Charwell-Coronial, of the 21st of August 2020. You see that?
Yes.
And those present at the meeting include yourself, along with Superintendent Pollock and Assistant Commissioner Antisich. You see that?
Yes.
And if we could turn to page 3 of that report, of those minutes, please, Court Clerk. If we could scroll down a little bit further, you'll see the sentence in the middle of the page there, trend analysis of use of force formed part of collation of information regarding members with military experience. Do you see that?
Yes.
And that trend analysis was something that you undertook and included in your Coronial memorandum, correct?
Yes.
And it showed that ex-ADF members were more likely to use OC spray, tasers and firearms, correct?
Yes.
Mr. Pollock, are you aware of studies from the United States?
I'm Proctor, not Pollock, sorry.
Apologies, Mr. Proctor. Are you aware of studies from the United States that former military personnel are significantly more likely than other police to have fired their weapons while on duty, are overrepresented among police who have had use of force complaints filed against them, and would appear to be overrepresented in fatal police shootings?
I can't recall if I read those studies as part of my preparation. I know in this document I do reference some research I was able to undertake in relation to the militarisation of policing from the USA, but I can't recall if it contained those particular elements.
Right. For your honour's benefit and for my learned friends, those studies are referred to at paragraph 22 of Professor Caneen's report at 10-10AA of the brief. If we return to those minutes, Mr. Proctor, you'll see that the paragraph immediately below the trend analysis states, militarisation of police, including recruitment training, is it combat or police training, whether there is anything in place reprogramming or retraining behaviour? Do you recall that being discussed at this meeting?
Yes, and again, I think I addressed that in my report. As part of that, we contacted all the jurisdictions to see whether or not they had in their police training anything that was specific to ex-military members in relation to the role that they have in the military compared to the differing role they have in policing. The only advice we received back was that Tasmania have a small component of their recruit training which focuses on the emphasis and the skills of community policing.
And focusing on the Northern Territory Police Force, is it the case that at the time you retired, there was no training that was focused on the reprogramming or retraining of ex-ADF members who were entering the Northern Territory Police Force?
Not that I'm aware of, no.
Mr. Proctor, would you accept that with an increased militarisation of the Northern Territory Police Force comes an increased risk of police officers operating with a paramilitary mindset?
Yes, I think that's a fair... Yeah.
And with a greater focus on force to resolve situations?
I don't necessarily... I can't say whether it would result in a greater use of force. I think when you look at certainly the research I did, there is I think ex-ADF members are more comfortable in the use of force perhaps than police officers who haven't been trained, who haven't received that type of training. As to whether or not there are higher incidents of use of force, from ours it was very hard. I don't think we saw that it was significantly higher or not.
In your Coronial memorandum, you discussed the Peelian principles of policing. Do you recall that?
Yes.
Those principles.
Please don't ask me to recite them now, because
No, well, I can read the sentence to you. They include matters like policing by consent,
Yes.
Respecting community principles, obtaining the support and trust of the community, and using the minimum force necessary. You agree with that?
Yes.
And could I suggest to you that the risk of adopting a paramilitary mindset is that police are moving away from those Peelian principles of policing? Do you accept that?
Yeah, and I think in the current environment that we face, not so much in remote communities, but certainly from a broader policing environment across Australia and certainly the world, it's a balance between that. So does there need to be a paramilitary style of policing in communities like Yuendamu or our remote communities, where that paramilitary is primarily focused around terrorism? I would submit no, it's not the case.
I'd like to ask you in particular about the prevalence of a paramilitary mindset within the IRT in Alice Springs in 2019. Could I ask you to turn to page 32 of your Coronial memorandum? What you'll see on this page is a summary of IRT call-outs that Constable Rolfe was involved in.
Yes.
And if you look at the first entry for the 2019, which is the 27th of February of 2019, the summary there says 2 vehicles and firearm with ammunition were stolen from numbers, a property in Araluen. IRT members Bowens, Rolfe, Hanson, Everett Smith called to locate SMV and recover firearm. Vehicles were initially used which located one of the stolen vehicles. A pursuit was called, but it was later called off. A helicopter was used to try and locate the vehicles. Rolfe deploys with AR-15 in helicopter. Search later called off after vehicles not being located. Mr. Proctor, is the deployment of a constable with an AR-15 in a helicopter an ordinary policing operation for the Northern Territory?
No.
Obviously, you had nothing to do with this incident, but you do have 34 years' experience in the Northern Territory. Would you be able to assist us in what the plan might have been to deploy Constable Rolfe with a semi-automatic assault rifle in a helicopter?
No, I can't. I wasn't involved in that.
Would you agree that we've moved a long way away from the Peelian principles in this situation?
Yes.
If you go to the next incident immediately below that, the summary says, community unrest in Borroloola, 2 IRT members called to supplement TRG members to maintain peace. Members Rolfe and Bowens attended in camouflage uniform with full kit. Do you understand full kit to mean including AR-15s?
Yes.
Putting aside what we now know about Constable Rolfe and Sergeant Bowens and their text messages, how do you think the community would feel with 2 police officers arising for the purported purpose of maintaining the peace in camouflage gear with semi-automatic long-arm rifles?
In relation to the firearms, it isn't clear, I'm not trying to be funny here, but it isn't clear whether or not they were openly displayed or not. So it may be that the community may not have seen them. Certainly the presence of police in camouflage is quite concerning in communities. And I don't know what the rationale for the camouflage was or for what their duties were. Normally, as in this case that we have before us, a deployment for general support is normally undertaken in uniform, police uniform, unless the specific plans or roles require camouflage. So if you obviously are going to be hiding in the bush or doing those things, you're not in a uniform that has reflective materials on it.
Community could be forgiven, couldn't they, for thinking that this was the arrival of a military unit rather than police to come and maintain peace?
Absolutely, and that is why in the past, when other sections have deployed, unless there is a specific requirement to the task that requires them to have, as I say, the camouflage for operational purposes, it is normally in full police uniform.
Mr. Proctor, would you agree that the creation of elite units, such as the TRG or IRT, risks damaging recruitment by encouraging and rewarding applicants with a military bent?
I suppose I'm going to pause there and say I personally don't class the IRT as an elite unit. As I said before, to me it's a unit of general duties officers who have been provided with skills enhancement to do a specific task.
And provided with military grade weapons and uniforms
Yes,
to do
but
those
that
tasks.
doesn't necessarily make them elite. But I accept that in relation to the TRG, can you just repeat the question, sorry?
I asked, do you consider the creation of units such as, I use the word elite, but I understand you're quibbling with the word elite. Creation of units such as the TRG or IRT risk damaging recruitment by encouraging and rewarding applicants with a militaristic bent?
That's hard for me to answer because I don't necessarily believe that if someone has military experience, that it is taken as a higher criteria for, certainly in my experience of managing the TRG for several years. For the TRG, even though again it's a police tactical group, you have a large number of members there who have had remote policing experience because of the diverse duties that they are required to undertake, which can include general support. So I don't always think that it's the military training that gives them a hand up, for want of a better term, to get into those areas.
Are you aware that on the brief before Her Honour is a text message from Bree Bonney that reads, "Police experience doesn't have fuck all relevance to TRG in comparison to Army, selections are retarded." Have you seen that message before?
No, I haven't.
Given the nature of the TRG work, would you accept that it would be understandable the opinion of police officers was that military experience was more relevant to becoming a member of the TRG than other things?
That's obviously the view of that officer. I gather that person is a police officer?
Yes.
I'm not sure in which context that is written. In my experience of managing the TRG, the entry process is quite robust. The selection process at the end of the day goes down to a transfer panel which is not part of the TRG. But certainly in my time there, yes, we had members who had military training. We also had a significant number of members who had worked in locations such as Wadeye, Ali Karung, Tennant Creek, because they bring an additional skill set. And really, even with the military training, we still require those people to undergo training in accordance with the ANZ-CTCP Police Tactical Group requirements.
I'd like to ask you about an opinion that's been expressed by Professor McCulloch, who's provided a statement that's on the Coronial brief.
McFarlane?
McCulloch.
Oh, sorry, thank you.
It's at 10-31A from a learned friend. Professor McCulloch says, "The separation between police and the military is morally grounded in the notion that it prevents police from adopting a mindset in which they believe they are fighting a war against the same people they are supposed to protect. The military, unlike the police, are not obliged to gain or maintain the support of the people they are acting against, as they do not purport to act with consent. Paramilitary policing, then, is the antithesis of community policing, which strives to work with and be inclusive of the communities served." Do you agree with that opinion?
Yes.
My clients will be submitting to the coroner, ultimately, that the IRT deployment to arrest Kumanjayi Walker had the look and feel of an undisciplined paramilitary unit. Would you agree with that assessment?
I don't know if I would say it was an undisciplined military unit. I would say it was perhaps undisciplined officers carrying military-type weapons.
With a paramilitary mindset?
I don't know what the mindset of the officers were.
Well, it's obvious from their actions that they weren't acting in accordance with the Peelian principles we've discussed, isn't it?
Yes.
We will ultimately be submitting that was a consequence of the increased militarisation of the Northern Territory Police Force. Do you have an opinion about that?
I disagree with that. I think it was a consequence, perhaps, if you read my report, of the systemic failures relating to supervision, management and compliance with policies and procedures of the IRT.
All right. I'd like to pick up that opinion that you've just expressed and come back to the idea of reprogramming or retraining behaviour that we were discussing a short time ago. Do you recall that?
Yes.
In your coronial memorandum, you cite the work of Close, and you say that it's not easy for ex-ADF members to transition from warriors to guardians. I think Mr. Bolton took you to that quote in your report.
I'm not sure if he did, but yep.
And what you go on to say in your coronial memorandum, I don't need to take you to it, but you say that their training and experience embed a mindset that doesn't always align well with the requirements of community policing. The coroner has heard evidence from Constable Sykes about his role in protecting Australian soldiers who are engaged in the mentoring and training of the Afghani National Army in Afghanistan. Did you have the opportunity to listen to or read that evidence of Constable Sykes?
No, I haven't.
You can take it from me that Constable Sykes was discussing the threat of a green on blue attack. You're familiar with that concept?
Yes.
And how it was necessary to be alert in that environment because the presentation of a threat required an extremely rapid response given the nature of the work. You'd also be aware, Mr. Proctor, because you've probably seen it in the coronial brief, of the expert report of Professor McFarlane.
Yes.
And Professor McFarlane talked about how hypervigilance can result in a greater propensity to attend to threat and a pattern of overreactivity. Do you recall that opinion?
Yes.
McFarlane goes on to address Constable Rolfe in particular and says that Constable Rolfe's preoccupation and concern about a blue-on-green attack may have been an underlying driver of his reactivity and could have had the propensity to trigger his training responses learnt in the military context rather than those learnt in the policing context. Do you recall reading that?
Yes.
Do you consider that there would be benefit in specific training for ex-ADF members to mitigate the risk of them adopting a paramilitary mindset?
Yeah, and I think I make that in one of the considerations in my report.
And do you consider that it is necessary for the Northern Territory Police to proactively monitor ex-ADF members to identify any concerning trends in their use of force and, if necessary, be in a position to intervene early?
I think, as I put in my report, I don't think it should just be limited to ex-ADF members. I think there needs to be a greater monitoring of use of force so you can have early intervention. I think it applies across the board.
Do you accept, given the comments of Professor McFarlane, there might be even a higher risk amongst ex-ADF members?
Yes.
And that would highlight the particular importance of monitoring of ex-ADF members, would it not?
If you had that system in place, you could possibly put that flag on ADF members, but I think the starting point is to have a system that monitors all police officers who may use excessive force.
All right. Mr. Proctor, there's just one other thing I'd like to ask you about. And if I could ask that we return to those minutes of the JMC meeting of the 21st of August 2020. And if we could go to page 1 of those minutes, which I believe is page 89 of the document, and scroll down. Yes, thank you. That's good. Do you see the paragraph there starting agency continues?
Yes.
It says agency continues to write policies, however we keep falling short. Noted that the coroner may run out of patience with this. We need to be able to not only say we have written a policy, but what have we done since then? We need to be able to prove what we have done. Do you recall that being discussed at the meeting?
Possibly, but I'm not sure who that comment's attributed to, whether it's myself, Mr. Antisich, or one of the other people that are present.
Regardless of who expressed the view at the meeting, is it a view that you agree with?
Yeah, I think it's extremely important in any coronial inquest that we, by the time we get to the coronial inquest, we've at least indicated to the coroner, as is the case with the Operational Response Committee, that we have commenced actions in relation to the issues identified. They may not be completed, but at least you've either considered it or you've done something.
And I take it that when you say commence actions, that is separate and distinct from creating a new policy, for instance.
Well, an action could be creating a new policy to address whatever that particular theme or issue may be.
Would you agree that policies are only effective to the extent that they are actually implemented, enforced and complied with?
Yes.
A policy itself may reflect a general acceptance of a need to change, but without practical day-to-day compliance, they're effectively meaningless.
Yes.
They're my questions. Thank you, Ron.
Thank you.
Your Honour, for the next council, not to hurry anyone up, just to get a sense of where we are and whether we might finish before lunch. I wonder whether I could get a sense of who's left to examine and how long. Probably about 10 minutes.
We have nothing at this stage, Your Honour.
I have some questions, possibly 15 minutes or so.
Oh, hopefully we can finish before lunch then. Yes, Mr. Officer.
Mr. Proctor, my name's Luke Officer, as you know, I work for Constable Ralph. Good to see you again.
How are you, Luke?
How's the golf? I'll ask you.
No good today.
Mr. Proctor, you had a very lengthy and distinguished career as a police officer.
I've had a lengthy career, yes.
And part of that, would you agree, included you using your own force over the course of a career?
Yes.
And when I say use of force, empty hand tactics or use of accoutrements.
Yes.
Did that also include a period of time where you would be the supervisor of other police officers who use force as well?
Yes.
And would that include when a case note entry or use of form is submitted, you would review that? Have you done that in the past as well?
Look, I think that came in when I was either a superintendent or commander, so it wouldn't be something I would have done as part of my role as a sergeant. Certainly, I think as a superintendent or commander, I might have reviewed some that were referred, as a commander, only those that were referred that were required my view. But yes, I have reviewed use of forces.
And you've also been commander of Professional Standards Command in the past?
Yes, I have, that's correct.
For several different secondments or?
I think it was one, but for a period of months. It was after the Mr. McRoberts issues.
At the top of page 29 of your report, have you got that there? I just want to give it a copy. Clark, if you could just pull up brief item 7, marking 4 capital A. It's a different topic I'll come to, but at top of page 29, you commence with a use of force history.
Yep.
And use of accoutrements by Constable Rolfe, and you start with the analysis of 46 use of force incidents. Just on that point, can I ask, is 46 use of force incidents for a police officer in a period of some 3 years, do you regard that as concerningly high?
The data, from my understanding, a use of force incident or the recording of a use of force relates to the use of handcuffs, batons, OC spray, or firearm, and then there's a breakdown in there.
Yes, you're going to say there's 22 occasions of a use of force option.
Yeah.
I'm just simply focusing on use of force incidents, and there being 46 identified. Whether that is causes you any alarm over a 3-year period for a police officer to be involved in that many.
I'd have to look at the other data we had in comparison to others, if I may, because it's very hard for me to say that 46 is high. It depends on the location in which the officer is working. For example, if the officer was a sworn officer working in the firearms unit and he had 46 use of forces, I would submit that would be...
Sure, so it depends on what they're doing.
Yes.
If I could put it this way, if that's 46 use of force for a general duties constable in Alice Springs, would that cause you any alarm as to that being overly high?
Not necessarily the use of forces, it's whether or not then they were determined on review what type of force was used and what are the circumstances of the force, and of course if any of them were excessive.
If I skip down then to the bottom of page 29, an analysis of use of force data and involvements NT police wide for the period 16 December 2016 to 9 November 2019 was also undertaken to identify the top 20 officers with use of force involvements. The top 20 officers are represented in the chart below. Rolf is not recorded in the top 20 officers.
Yes.
And you'll see that in the first column to the left, at least on my examination, there's a member there which has almost 100 use of force recordings, and that, as I understand it on that chart, is related to the deployment of an accoutrement only. Is that right? Is that what the colours signify?
Yes.
Handcuffs, baton, OC, taser, firearms.
Yeah, and I can't quite... sorry, my printouts, and it's probably not a very good graph, but I don't know which particular accoutrement it is, but yes.
But that's almost 100 use of force involvements with an accoutrement in a 3-year period of a particular officer.
Yes.
And so, would you agree that there's also the possibility, given that Constable Rolf had 22 occasions of a use of force option in a total of 46 use of force incidents, that particular member could have had well over 100 use of force incidents over a 3-year period?
Quite possibly.
So can that give you any assistance to indicate whether or not, as a general duties police officer, a constable, whether 46 use of force or 22 incidents of using accoutrement is concerningly high?
I wouldn't say it's considerably high, and particularly now when you draw across the top 20 of the organisation.
Constable Rolf didn't feature.
I wouldn't say that it was exceptionally high, no.
Right. I'll just move to a different topic. And Madam Clerk, if you could just pull up that. Right. Marie has disappeared. It's the affidavit of the Anderson.
I've got a hard copy there.
I do. I've just magically found one in my bag. I don't even think it's marked.
Just check this one marked here.
Give it all. Yeah.
Oh, thank you.
I think they might now be out of order as well.
I'll take you to it. Mr. Proctor, if you could just start going towards the back of it. And it's a memorandum NAA-08, which is the annexure reference, and it's a memorandum.
So it's an internal memorandum, is that correct?
20th of October 2020, which is from
Oh, yes, yep.
Scott Pollock to yourself.
Okay, I've just got to find the bits, excuse me for 1 second. Is that 008 or 009?
008.
I think I've got the right bits together, but I'm not in. I think I've got one with the paragraphs 1, 2, 3 and 4 on it, but I'm not sure about the other pages. Yes.
Yes, that's right.
Okay.
I don't want you to, I'm not going to take you through it in detail, but that memorandum from the 20th of October 2020 from Scott Pollock to yourself,
Yes.
in effect, raised concerns about Detective Senior Sergeant Barham's use of the DIMOP model in his expert opinion that was provided for the prosecution of Constable Roth.
Yes.
You recall that? And in particular, at paragraphs 5, 6 and 7, he referenced, in effect, that it was outdated, no longer relied upon, no longer part of the training package. That's Scott Pollock's opinion.
Yes.
Did you share, having read that memorandum, and I'll take you to the JMC that occurred after it in a minute, did you share that concern of Scott Pollock?
Yes, and that report was forwarded through to the Assistant Commissioner of Crime,
Who was Mr. Antic?
Mr. Antisich, and I think, I don't know if my handwritten comments appear on that one, but I think my comments were that the issue raised needs to be clarified and should be forwarded to the crime team, to Mr. Antisich, and for discussion with the DPP in relation to evidence at the trial.
Yes, and indeed, if you recall, I think Peter Kennan looked at
Yes,
Pollock's,
that's correct,
Pollock's
yes.
memorandum and provided his own,
Yes.
which Peter Kennan's view was that there was no concern. Do you recall that?
I recall the memo coming back, and I think there was also some commentary around a conference that had taken place with the DPP.
And can I ask you on that same document you've got there, the affidavit, turn forward to NAA number 10, Annex number 10, which is the minutes from JMC number 4, Operation Charwell.
Yep.
You attended that meeting, it's got you located at the top there.
Yes.
Do you have a recollection of that meeting that you sit here?
Yes.
You seem pretty confident of that, why is that?
Well, when you read the minutes, you'll see it was a fairly robust JMC.
Yes, and I just want to put some of the following which were noted in the minutes. Did you
Just ask for the page of the PDF so I can.
Oh, it is page 93. You didn't make the minutes yourself, was that someone else?
The meetings were recorded, and my understanding is that then practice. My thoughts were that they were recorded and the recordings were kept, but the practice on the top floor was that they were then turned into minutes, and the minutes were then disseminated. So, yes, I had read these minutes and agreed that they were a reasonably accurate reflection of the JMC.
I just want to read you these 4 paragraphs from that and then ask for your comment on, by reference to the issues raised by Scott Pollock about the DIMOP model. This is on page 94, that 4th paragraph. NA, I assume that's Nick Antisich, reiterated that he is not saying the coronial investigation is not to continue, but it is suspended. DP, I assume that's you, questioned whether this means all evidence will not be provided to the court, but rather information that fits the prosecution. Nick Antisich noted that investigators do not agree with SP's report and recommendations. Now, when you raised that your concern or your question that evidence was not going to be provided to the court, but rather information that fits the prosecution, what did you mean? And what was the response you received?
I think this was around. I have to read the minutes to put that into context. The meeting minutes to put that into context. I think it was potentially in response to the top paragraph where I think it says NA feels we have gone well beyond determining the cause of death for the conduct and preempting a criminal trial puts us in precarious and difficult positions.
Yes, all right. And then about the paragraph about the middle of the page stating DP noted that NA, he has concern that if the investigation is suspended, they will be exposed if there are items in the prosecution brief that are not correct or identified as being incorrect at trial or subsequent coronial, that NA's direction to suspend the investigation prevents them from being identified prior to the criminal proceedings going ahead. DP noted he will not take responsibility for this. And then over the page, Mr. Andisic noting concerns about the prosecution case being undermined, and then the perception you find it offensive, this is on page 95, that the information should have been fact-checked by the investigators before getting to the prosecution team. Can I ask you, those concerns that you had about correct information, did they directly relate to what Superintendent Pollock raised with respect to Detective Senior Sergeant Barham's opinion, including the use of, or about the use of the DMOP model, or was it something completely different?
It was specifically in relation to that.
Yep.
But I think what I was trying to convey was to suspend. At this stage, we weren't investigating per se, but we were still compiling a report and reading through lots of information.
Yes.
My concern was that if we came across information, as in this case, which I believe was answered subsequently, satisfactorily, but if we came across this information and did not provide it to either the Assistant Commissioner for crime to then discuss with the DPP, that placed the organisation in a significant risk and us in a significant risk, and given that we were acting and investigating on behalf of the coroner, it also placed the coroner's office at significant risk, and as I say there, it was not a risk that I was willing to take.
Yes, so your concern was the accuracy of information that is being used and compiled in an expert opinion for a prosecution being factually correct, and did it seem to you that Assistant Commissioner Andisic was not bothered by it or troubled by it?
No, I don't think that was at all, because he actually, in the first memo when that's raised, he referred that on to the crime team and the DPP. And my understanding when you read the whole of that is that was discussed with the DPP and then addressed through a subsequent statement. So I don't think it was concerned with it. I think he was more concerned that, I think there's a term somewhere about testing evidence or whatever. I think his concerns were, was there a potential that us looking at things might create a problem in relation to the criminal proceedings? I couldn't give you a specific example of where we, outside of this, where we had found something of this nature, and but my concern was more around the decision to suspend, which was cancelled after 3 days. But for me, it was very much about we were investigating on behalf of the coroner in accordance with the Coroner's Act, and I didn't believe we were undermining the investigation or doing any of those things. We were just doing due diligence.
No, your point is that if someone raises a concern about the factual accuracy or the truth of something, that be properly examined to make sure that what is presented is factually correct and true.
Yes.
Your Honour, I'm not sure if those audio recordings have been called for from the meetings or are available.
I don't believe they're available. When we, if I may, when we prepared the subpoena for the Supreme Court, I don't believe the one for this particular, I don't know what's been found since, but the one for this particular matter, I don't believe was in existence.
What happened to them?
As I said, I think the practice was that once the minutes had been prepared and signed off in accordance with everyone being in agreement, then the recordings are no longer maintained.
They're deleted?
Yes.
Is that for every JMC meeting?
I don't know.
Do you think that's wise to delete the audio recording?
It's a practice that's recognised and accepted by the company directors course, being no longer a policeman, but a policeman of 34 years. I like to keep minutes, but I can, as I say, that wasn't my decision. It's just a practice that's on the sixth floor of the organisation.
And apart from the minutes and the audio recordings, did anyone in these JMCs keep handwritten notes?
I don't believe so, because we were of the view that the audio recording was even better than our handwritten notes.
Even though it's going to be subsequently deleted?
Well, as I say, at that stage, I didn't know it was going to be deleted.
Nothing further.
Yes, any other questions?
Your Honour. Oh,
Sorry, Miss.
I just have a few questions, Your Honour. Yes, please. Sorry.
There's also Mr. Castleton on the phone. We're just checking whether he has any questions.
Mr Proctor, as you know, my name's Sally Oslins. I am appearing in these proceedings for the Northern Territory Police Association. Just at the commencement, am I right in thinking, and please correct me if I'm wrong, that immediately prior to going over to take over the Coronial matter, you were the commander in charge of PSC?
No.
No.
So, Sally, my secondment to PSC, I think, was about 3 or 4 months. And it was a secondment that occurred after the suspension of Commissioner McRoberts. I can't remember what year that was now. And I was seconded across to do some investigations in relation to the circumstances around that, and then also for PSC while the other officer involved was on suspension.
Right. So we've heard a lot of evidence through the course of this inquest about supervision and leadership, and you've, I think, rejected this morning the comments made by Mr. Antisich earlier this week that any failure by managers to properly identify red flags, if you like, in behaviour was corruption. Have I understood your evidence this morning correctly?
Yeah, I suppose in my view, I don't think it is corruption, unless unless you could show that they deliberately and purposely ignored those things. I think one of the things that concerns me is the systems that are absent for, and there's two elements to this. It's evident here that we have systems in place where supervisors have not done due diligence on certain aspects, but I think, as I put in my report, I think there's also an absence of systems and also guidance or training for some supervisors.
Sure. I think you actually said in your report that the training, experience and willingness of supervisors and managers to address poor performance or behaviours which can lead to inconsistency in how procedures are undertaken was one of the issues that you identified. And I think from what you've said just now, there are a number of things that can factor into those failings. Would you agree that a high turnover in staff could be a contributing factor to consistency in supervision?
Yeah, and I think I do make that point in the report when we looked at the number of supervisors of Constable Rolfe in Alice Springs. And then, from my experience, at times, number of acting supervisors. And quite often, it's easy for me to sit here and say, oh yes, people should know or people should be trained. But quite often, due to illness or emergent circumstances, the requirement for a member to be put into an acting position doesn't always necessitate that they have that level of experience or training.
Yes, and Alice Springs, like most other regional areas, has a significantly high proportion of probationary and junior constables, does it not?
Look, I would have to speak historically because I don't know what its establishment is present. Yes, it does. But I think at the same time, for me, it's more around the circumstances. I think when you're looking at, for me, in the use of force place, I was very conscious that at the moment the current policy only talks about 4 words, for want of a better term, that you have to satisfy. And it doesn't look at broader aspects around use of force in terms of the events before, leading up to the actual use of force at the critical point.
And is that what you were talking about earlier when Miss Moreau was asking you questions which involved the implementation of IAPRO, I believe it's called?
IAPRO is one. That's about more the management of the workforce. When I looked at some of the use of force reviews, it's clear that there are inconsistent findings on use of force reviews undertaken by supervisors. That goes to the point where I think that system has failed.
Can I just query, I understood that this IAPRO has capacity to track and monitor and identify red flags, but it's actually only utilised as a case management system. Is that right?
It does have, I'm not sure if it does now, certainly in a previous version, it's all around licensing. It has a capacity, it's only as good as the information you can put in it, but
Yes.
you can put information in it that allows you then to look at whatever parameters you want to put into it.
But as I understand, it was never utilised that way by the Northern Territory
Look,
Police
I think
Force.
historically it might have been for a short period of time, but I'm not sure.
We've heard some evidence in the inquest that particularly sergeants in regional areas have had an increasing number of administrative duties over a period of time, which has resulted in a reduced capacity to spend time on the road with their patrol groups. Is that something that you've observed?
I would have to be honest, I really can't answer that, Sally. I haven't been a sergeant for a long time. I think there is, we've seen an increase in the workforce. I'm not sure whether the number of supervisors have increased. I guess you would class the requirement to assess use of force as an administrative task, because obviously that isn't something that is done in the field.
So the evidence that we've received indicates that sergeants and senior sergeants spend a lot more time desk-bound rather than out on the road. Is that something that you can comment on?
From a senior sergeant, depending on the role they're undertaking, so if you're an officer in charge of a station, I wouldn't expect that you'd be spending a lot of time out on the road. If you're a watch commander, I think that's a different story. And I don't know for Alice Springs, I can only really speak for Darwin. I think there are times when they are required to be behind the desk, but that's what you have saying. It would be really hard for me to answer 12 months out.
That's okay. I think we were talking earlier about training and mentoring being a key factor in ensuring that things like use of force, if there are red flags, that they're picked up, but training and mentoring for the sergeants and senior sergeants who are expected to undertake these reviews, you'd agree, wouldn't you, that the training and mentoring for those sergeants and senior sergeants is very important?
I think training and mentoring, and I also think ensuring that you have a system by which, if you're going to, let's stick to use of force reviews, you have a system that allows those sergeants and senior sergeants to undertake that review in a consistent manner.
Sure, and I think that was something that was referred to by Mr. Antisich in his 2019 report, or review rather, into the disciplinary processes, but that the training officers had to be equipped to do the work that they were being required to undertake.
Yeah, I think there's equipped, but I think for me, the system, as I say, as part of this report, the system also then will identify whether or not officers, those undertaking those assessments, are providing due diligence to the assessment process.
Yes.
Which then should feed down to the officers using force if there are areas
yes.
where...
And similarly, if the sergeants and senior sergeants are not trained properly to do that proper due diligence in a consistent way, that's going to have an impact on how the flow down effectually, because obviously they're supervising, but every sergeant has a supervisor,
Yes.
Every senior sergeant has a supervisor, every superintendent has a supervisor, and right up to the Commissioner of Police himself.
Yes, that's correct.
We have heard both Assistant Commissioner Wurst and Superintendent Nobbs describe the position of a sergeant as being critical in policing, and in fact I think Assistant Commissioner Wurst said it was, in his view, the most important position in the police force. So I just wanted to ask you about your understanding of the training for sergeants generally, and there is actually a general order in relation to qualification and development pathways, isn't there? And what was in place certainly when you were in the Northern Territory Police Force.
I think there were that many changes to the promotional framework prior to my leaving that, in all honesty, I couldn't give you a firm opinion on that pathway and development.
Yeah. Do you have any recollection prior to leaving the police force? I understand it hasn't changed, but I'll certainly be corrected if I'm wrong, that in order to progress to a sergeant position, senior constables had to meet a number of requirements, but one of them was completion of the Northern Territory Police Force College Sergeant Qualification course. Are you familiar with that course?
Of that particular iteration, I'm not sure. In previous roles, I have delivered training at the college to sergeants and senior sergeants in relation to command and control, and I think we had a program developed by Superintendent Gill and myself, which was the Strategic Incident Command course for senior sergeants.
Right, but not particularly qualification courses.
No.
And in fact, my understanding is that that particular course, which is, according to the general order, a precondition for appointment as sergeant, that particular course hasn't been run for many years.
I'm not sure. I think my last recollection was it was an assessment centre process, so I can't probably help you there. My apologies.
Would you agree that that sort of training, in addition to other courses, which at least... Sorry, I've just lost my glasses and I can't read the ink's too small.
What was the name of that general order that you were referring to, Miss Osborne?
Your Honour, it's the General Order Rank Qualification and Development Pathway, and I apologise for not foreshadowing, relying on it earlier. It was something that was brought to my attention just recently.
Is it in our brief?
I don't believe so, Your Honour. There's a flowchart attached to the end of that general order, Appendix A, and it provides a flowchart for promotion through the various ranks. And it specifically states that mandatory for promotion is from senior constable to sergeant is the completion of the sergeant qualification course that I've just referred to. And it's also desirable for people seeking promotion to undertake a leadership and management course, and also a strategic incident command and control course.
Yep.
Are you familiar with those?
I'm not familiar with the first two. I am familiar with the third, which is the Strategic Incident Command course.
And are you aware of whether that course has been run in the last 5 years?
It was certainly being run prior to my retirement, and even with I ran that course while I was the commander of TRG and the like, and I am aware that the course was still being run by members of the TRG, senior members of the TRG, because it is about command and control and the like, but I couldn't tell you when it was last run.
Sure. And similarly, for promotion to senior sergeant, there are mandatory requirements of obviously continuing education, but also this advanced leadership and management course. Are you aware of whether that has been run?
I couldn't help you with that, I don't know.
Okay. I just want to move on to we've been talking about the review of Part 4 of the Police Administration Act. I see you smirking. Your name has been on a number of the working group documents and discussion papers that have been published.
Yes.
And I just wanted to gather your views in relation to the Part 4 processes. We did hear some evidence from Mr. Antisich the other day, and we've also received a copy of the review that he undertook. And just in summary, he seemed to acknowledge in his report that there was a very punitive approach for a period, and that with the suspension of the operation of Section 14C by the former Commissioner, that is Commissioner Kershaw, that there was a significant increase in serious breaches of discipline being dealt with under Part 4. Do you agree with that?
I don't know. I don't know the figures to say that there was a significant increase. What I do know is that with 14C being removed, the options available to prescribed members where minor matters had occurred was taken away. So then obviously the Part 4 provisions had to be applied.
Yeah, and I think Mr. Antisich also commented in his report that there were a number of matters that were being dealt with by way of Part 4 disciplinary proceedings, which an assessment had indicated were more managerial or HR type matters.
With the removal of 14C, Part 4 kicks in, of course, and when you might apologise, I don't have a clear recollection of every single provision under the options available to members, but of course one of those is to take no further action. From my understanding or my experience, Part 4 was still used to provide the opportunity of a member to provide a response to whatever that issue was, and then consideration of what action needed to be taken by the prescribed member. So I guess, for want of a better term, it was using Part 4 perhaps as a management technique for lesser matters, but unfortunately, because of no 14C, they fell into the serious discipline part.
Yes, so obviously if it's Part 4 is being used, which is obviously titled serious breaches of discipline, but it was being used as a management tool, I think Mr. Antisich gave evidence that there was then, from his perception anyway, an increased desire by members, if you like, to fight proceedings, if you like, or to not simply acknowledge what was being alleged and moving on. Do you agree with that observation?
It's hard for me to agree with that because I wasn't in professional standards or have the information that Mr. Antisich had to make his opinion. The only observation I may make is that under Part 4, as you're aware, there are a number of, I call them options, but available to members, and one of them is dismissal. So when you serve a notice on a member, the options that you have to include them all includes dismissal. And that could be a inhibiting factor in members acknowledging the breach of discipline and not contesting it.
Yeah, because it might be the case that it's a minor breach of discipline, but they're being advised that they're at risk of dismissal effectually.
Yes.
I just wanted to go now broadly about the welfare of members, and I note specifically that in your, sorry, if I could just have one moment. In your report, you were talking about the guidance that was provided by the Northern Territory Police General Order, Death in Custody and Investigation of Serious or Fatal Incidents. You said, resulting from police contact with the public in relation to the separation of witnesses has been provided to ensure that as soon as possible after an incident has occurred, systems are put in place and directions are given to minimise the conferring between witnesses and the contamination of evidence, whether consciously or unconsciously, and that's at page 97 of your report. I think you were talking specifically there about the potential contamination of police evidence. Are you just looking for the report, Mr.
Yeah.
Proctor? Sorry, yes, it was
Apologies.
page 97 I was reading from.
That's not it. I think I've misplaced it somewhere.
Well, it should be big enough that it won't be lost.
He's on iPad.
No, I think he was given a hard copy.
Yeah. Is that it? Oh, thank you. My apologies. What page was it again? My apologies.
97.
Thank you. Could you just refer me to the paragraph again, please?
Oh, sorry, it's just the part where you're talking about, and I'm paraphrasing, systems being put in place and directions given to minimise the conferring between witnesses and the contamination of evidence, whether consciously or unconsciously.
Yep.
And I gather there you were talking specifically about the potential contamination of police evidence.
Yes.
And you go on to say at page 98, any indication of evidence of conferring has the potential to undermine the integrity of an investigation. You obviously agree with that because that was what you wrote.
Yes.
You also separately had raised concerns about police members being reluctant to provide statements. And I think one of the examples you gave was Dr. Beer querying if she was providing a statement in a voluntary way or in a coerced way. So you identified a number of issues with the gathering of evidence in this particular investigation. And I just ask you to comment on or to indicate, would you agree that those same concerns arise in relation to civilian statements and ensuring that evidence is taken as soon as possible in order to avoid potential contamination of evidence?
Yes, but I think, as I highlight in my report, where police are concerned, there's an expectation on police forces where police are involved in these type of incidents that the integrity in the investigation is of the highest order. So, unfortunately, by being a member of the police force, you are held to a higher standard.
Yes, yes. But there were some concerns raised about the difficulty in police members obtaining statements in the community in the initial stages of the investigation, wasn't there?
Look, I'm not sure. I wasn't present when the initial investigation was undertaken. I think that was perhaps in Mr. Pollock's evidence.
I think it was. It's referred specifically to. I'm going to get his rank wrong. I think it's Superintendent Penuto, was Senior Sergeant at the time, has referred to various challenges in his notes. But what you specifically comment on is concern that specifically Aboriginal witnesses were not offered a support person when they were being interviewed, and none were offered counselling in the context of statements being taken, and that's about page 100 in your report.
Oh, yeah.
You acknowledge that it was established that the witnesses that you were referring to had a reasonable interpretation of English, but you reiterated the need for a support person or counsellor. So do you agree that where people have experienced a traumatic or critical incident, it's important to ensure those people are supported through the process of reliving the events?
Absolutely, but I think it's also important when you're taking statements or interviewing anyone who is subject to trauma, or particularly in my experience in dealing with Indigenous Aboriginal people, where they're intimidated by the police presence, and also to remove potential criticisms, in my experience, and statements. We've got ANUNGA guidelines and a whole raft of policies, procedures and case law to support people who English is a second language or who are from Aboriginal communities. So I think it is important, but again, it has to be a decision. I think you've got to have a policy in place, and then it's really down to the decision of, in this case, perhaps the senior investigating officer, as to whether or not the urgency of that statement is required.
So just on that, I mean, you'd accept that police members who are involved in critical and traumatic events would also suffer, not obviously those things particular to being Aboriginal or having English as a second language, but you would accept that police members involved in traumatic incidents are going to feel and experience that ongoing trauma by reliving events in giving statements and things of that nature.
Yeah, absolutely. But I think the other side to that is that there is a requirement to at least obtain some form of account as close to the incident as possible. Now, that may be a 3-hour statement. It might be a point of 5 or 6 questions asked in a non-confrontational manner to get an account of what has occurred.
Sure. And in fact, the general order that we were talking about before specifies that it's essential that the duty of care and welfare obligations to members involved in an incident and their families be appropriately addressed. You'd obviously be aware of that. You note in your report that all welfare obligations regarding police members were met, except for the Northern Territory Police Force chaplain visiting the scene. That's at page 101 of your report.
Yes.
Can you just outline what the welfare obligations that you referred to, what were you contemplating when you said that all of the welfare obligations were met?
I think that was in relation to the notifications to ESS.
Do you know who undertook the notifications to ESS?
I'm not sure if that was done by the operations team in Darwin, but we did find that notifications to employee support services had been undertaken. So I think that.
Oh, sorry.
Yep.
Was there anything else, or just the
I think
referral?
from my recollection, when we looked at it, the general order had been complied with, and I don't have the general order or the policy in front of me, but I think it was ESS notifications. I'm not sure whether or police force or police association notified welfare officers. And I'm not sure if that I can't recall the general order specifically now. I'm not sure if that's a requirement that the police association welfare officers are notified.
Sorry, so you're referring to the Northern Territory Police Association's welfare officers?
Yes.
Okay. One other thing just arising out of that's in your report, at page 102, you specifically state the obligations under the general order are specific in relation to the provision of immediate welfare assistance, and NTPF is not responsible for long-term arrangements of welfare support. Just wondering if you could explain that.
I think that is in relation to. I actually don't have the general order in front of me, so I'm not quite sure what I was thinking about there. Whether it was in relation to welfare offered to the family, in terms of family counselling.
And are you saying that that sort of welfare support is not the responsibility of the NTPF?
Yeah, I don't think that the general order covers that.
What are your views on that? Do you think the Northern Territory Police Force does or should have responsibility for the welfare of members following traumatic and critical incidents?
I think it does already, but I think it is dependent on what type of welfare we're talking about. Unfortunately, it might be that if the members are suffering severe trauma, then obviously there are processes in place that go beyond that in terms of the work health.
You commented in your report that the general order as it relates to welfare may not be contemporary or fit for purpose.
Yeah.
Just wondering what you meant by that.
I think it was out of date.
The general order.
I think it was due for refresh. I shouldn't say out of date. It hadn't been refreshed from my recollection, and probably required some review and updating.
Are you aware of whether or not that has
I'm not,
occurred?
no.
Just on that provision of support, you noted specifically in your report, and if you'd like to have a look, it's at page 168. The paragraph starts, during the investigation, the Coronial team identified several instances where the actions of police officers, police unions, and social media commentary individually and cumulatively indicate a perception of bias in favour of Rolf. And you go on to give a list of things, but you've stated that the role of police unions and the Northern Territory Police Association in briefing all police witnesses, including Rolf. Now, can you just explain what briefing you were referring to there?
Can you take me to the particular?
The last dot point in that.
Yeah, the last dot point.
I have to say that was I think earlier I advised that there were points that Mr. Antisich provided to the Deputy Coroner for inclusion. That was one of those points. I think that might relate to, it would be difficult for me to say what he was thinking there, but it might be around the Ray Murphy's involvement, but I'm not sure what the specifics of it are. Ray Murphy was the lawyer, I think, for the Police Association. I'm not sure.
Okay, I'll check that. But as far as you're aware, there was no briefing of potential witnesses, was there?
I'm not sure what Mr. Antisich was alluding to.
No, but as far as you're aware.
I don't know. I didn't look into that.
I think that might be all my questions. Thank you.
Your Honour, Ms Osland's mentioned in her questions a reference to the meeting notes of the Police Working Group on the Police Administration Act. I haven't seen the brief reference if it is in the brief here. Otherwise, I call for those meeting notes given their relevance to the issues in relation to the complaints system.
Which meeting notes in particular are you calling for?
There's a police working group about the Police Administration Act, and only they were referred to in very broad terms, but the working notes, I assume, deal with the considerations that have been brought to bear within the police service about any amendments to the Act required to address some of these issues in relation to effective complaints resolution.
Do you have a particular year? Or?
I don't. I only heard that they were mentioned by Ms Osland's in questions.
Your Honour, it wasn't actually meeting notes, and I apologise if I gave that impression. It's a discussion paper. I don't think it was published in a public way, if you like. It was a discussion paper to assist in the review of Part 4 of the Police Administration Act, and I believe it was published at least to the working group in July 2021.
July 2021.
Yes, Your Honour.
Well, I call for the discussion paper.
All right. Does anyone want to respond to that call? I don't think it's for this witness. He's no longer with the police.
We'll have a look for it, Your Honour. The issues are superseded to some degree by the external report, which will be made available to the court and the council in due course.
Your Honour, I think Mr. Castleton indicated that he didn't have questions. He's on the line, and so I'll just wait for a moment, and if there's no objection, then...
Your Honour, Mr. Castleton speaking. I have no questions of this witness on behalf of Mr. Pollock. Thank you, Your Honour.
Thank you.
Your Honour, I have about 90 seconds.
Sure.
Mr. Proctor, you asked some questions about the disciplinary regime under the Police Administration Act. You recall that?
Yes.
And in particular, you were asked some questions about Part 4,
Yes.
which is titled Discipline,
Yes.
and its interaction with Section 14 sub
C.
14C.
Yes.
Now, Commissioner Kershaw, as he then was, directed that all disciplinary matters, no matter how serious, were to be dealt with under Part 4, correct?
No, he directed that 14C would no longer be used, so there is a slight nuance in
Sorry.
Yes.
With the practical outcome that
discipline matters would then be
dealt with under
under Part 4, under the processes of Part 4, yes.
Yes. That's the question I wanted to ask you. Part 4 prescribes processes. It doesn't say what the outcome will be in every case, does it?
It provides so there's a process to Part 4, which I think or if you haven't, you will be given evidence on. And then as a result of Part 4, a prescribed member, depending on rank, has a number of, I'll call them penalties, but options that can be provided that range from no further action to verbal caution to written caution to dismissal. And there's demotion and penalty.
I suppose the point I wanted to make is that the fact that 14C wasn't being used anymore doesn't indicate that across the board penalties were going to go up for disciplinary breaches. It just means that a more rigorous process was going to be followed, correct?
Potentially, but I think the process of Part 4 is quite rigorous.
Yes.
Whereas with the 14C, it is very much a low level for matters that don't fall into the discipline space for officers, sergeants, senior sergeants to have the capacity to manage the workforce using that provision of the Act. So it has some implications for it. Doesn't sit in disciplinary. So it is an outcome for the member. It has implications for the member. If you were subject to 14C, it meant that you might not be able to apply for a promotion, or you might not be able to apply for transfer, but it wasn't at the high-end penalty that Part 4 brings.
Can I just put an analogy to you, and you can tell me if you think it's a fair one. In this court, the local court of the Northern Territory, people are charged with minor offences from time to time, and ultimately a judge says, look, I'm going to find that proven, but it's not particularly serious, I understand the circumstances, and I'm going to discharge you without any further penalty.
Yeah.
That, in a sense, is the type of outcome that Part 4 contemplates in certain minor cases, correct?
Yes, but the process to get to that is far more complex than the 14C process.
Absolutely. And it's complex and rigorous in the same way that in the court, you would enter a plea, you would make a plea in mitigation, and then there would be a formal determination by a judicial officer that the conduct was not serious enough to warrant a penalty.
That's correct.
Can you see the public interest in ensuring that even though they might be minor, a rigorous process is undertaken before an allegation of breach of discipline is dismissed as being minor?
Yes.
Okay. The other thing I wanted to ask you about was the notion that the availability of dismissal as an option might mean that everyone is contesting. You're aware, for example, that offences like the offence of criminal damage carry maximum penalties of 14 years imprisonment.
Yes.
Graffiti is an example of criminal damage.
Yes.
If I was to scroll my name on Mr. Bolton's books, I would potentially commit the offence of criminal damage. Correct?
Yes.
If I got advice that I was going to be sent to prison for 14 years, I'd sack my lawyer, wouldn't I?
Yes.
So you have to approach these things with a degree of reasonableness and assessment of the seriousness of the conduct.
Yes. Yes.
That's it, right?
Nothing further? Thank you for making yourself available. I hope you don't have to go to court too many more times.
I'm hoping so too, Your Honour. Thank you very much.
And thank you for your you together with Mr. Pollock's very thorough investigation and report, which has provided significant guidance in relation to the issues that we have been addressing in this inquest. And we certainly would not have made the progress that we've made, or that I think we've made, without that dedicated piece of work that both of you produced.
Thank you very much.
We'll adjourn till 9:30 on Monday.
See you next year.
Yes, you will. Now, I heard someone say the other day we're adjourned for 2 weeks in April.